Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
No, I'm not Peyton Ansley John Milton. I am the agent authorized to represent Peyton Ansley John Milton as written in all capital letters.
Thank you. And as to Mr. Milton, is there a confidence concern, or is
I am not represented by anybody besides myself. In my sovereign capacity, appreciate you.
Thank you, Your Honor. I did have an opportunity to speak to him. I read him the reports.
Who is him?
Don't interrupt.
I read him.
You just sit quietly.
Thank you.
I read him the report so that he will understand the charges against him. He didn't wish to hear anything more about his rights, and he does not wish to be represented.
You gotta love a good DSHS sit. We don't have one today, but we have the next best thing. We have the next best thing. Welcome back to the Court of Public Opinion. I am the Recovery Addict. Thank you very much for being here today. We're here for part two of a First Amendment audit trial, which is it's not actually the First Amendment audit. This is what I would say is what is typically the end result of someone who is performing a First Amendment audit and ends badly. This is the type of charge you would get, which is an assault charge. Oftentimes it's a lower. This is a 4th degree assault charge. It's the lowest version of assault you can get. Basically, there were some hands. The hands were thrown, but there's like no injuries or anything like that. But yeah, we are getting ready to go back to court. We're hoping that everything is happening beautifully up there. Let's see. Nothing yet from the courtroom of the Thurston County District Courtroom number 4, but we'll watch for that. Would like to say, first of all, big shout out to Sample User, who says this live stream is the best. No, just kidding. It was Adam Nusky who was first in chat this time. Adam, congratulations. You have been in the top 5 habitually. For quite a while. I think you've won before as well. This is not a first offense for you. I'd have to pull your record just to make sure, but you know the punishment, you know the drill. Now, in addition to everything else you had going today, which I know your day was full. Your day was full. You had a full schedule, but now in addition to all that, you're responsible for keeping the internet running for everybody worldwide. So if you could just make sure you take care of us first and then yourself second, that would be great. So thank you, Adam. Congratulations on being first in chat. And make sure you get your 50-cent certificate that you get to fill out for yourself. Available on the merch page. All right. We have, let me turn that down and this up a little bit. Not that much. Okay, I think we're good. There we are. Where are we at in Thurston County? Let's do a quick little refresh here. I've got to keep an eye on this. Not live yet. Waiting for part 2 of this jury trial. Good stuff. I was just perusing on. I don't want to pull it up on my screen, but I was just on the Hill Ward Henderson website, which features one Mr. Shapiro. It features a Mr. Shapiro on it, and I was just reviewing because I guess it keeps it updated with his credentials, experience, professional civic newsroom, and published decisions. It looks like the published decisions page has not been updated to have his most recent decision shown on there. It does show a couple wins a while back, but this latest loss is not currently on his little bio page. I think that might be important for people to know, but I'm sure they'll get right on that. So that's awesome. All right, let's shrink this down. We don't need that anymore. I've got this working again. That's great. So we don't need this. There we go. All right. Wonder why not, Sheila? You're serious. It's probably just an oversight. There are so many things that you have to take care of at a law firm that updating the website with the latest loss is probably not top on the list. But, just and everything in good time. Warrior Woman, thank you very much. It's been a phenomenal journey, and getting to know all of you has just been wonderful. Yeah, this is amazing. Let's see. What is the punishment if found guilty on the 4th degree? This is a gross misdemeanor. Okay, so we're talking a small fine and maybe a small stint in jail. That's where it lands. There's not a huge sentence. I mean, I would be very, very surprised if there was more than a 30-day jail sentence. And 30 days I think would be long for this. But maybe $1,000 fine and 30 days in jail. We can look. Let's do a quick Google on this. Let's see, Thurston County, Washington. Okay, crimes have a maximum penalty of 364 days in jail and a $5,000 fine are classed as gross misdemeanor. So I was off by about a year on the jail time. So 364, so less than a year, and a $5,000 fine. That's the top end. Headshot Dave, welcome to the gallery. Your headshot looks fantastic, by the way. Good to have you, that blue courthouse by your name. Thank you for your continued support. Let's see. Megan Fox interview last night with Greg was awesome. Now we just need Whitney. I think we had Whitney on Rob with Lawn Lumber, and Rob's going to be on tonight. Rob sent me something and said, "Hey, keep this on the down low," and then Greg outed him during Megan's show. If you caught that, I'll let you go back and find that little gem that just slid in there. So yeah, I would say keep an eye on Rob's channel. I'm sure he's got some good stuff coming. All right, let's see. And tonight, of course, I think he has a show tonight as well. So if we're still going late when he starts, I'm not sure when verdict's going to be on this one, but if we're still going late, we'll probably patch you over there. All right. Let's see. It's not an arbitrary charge to have on one's record, though, as it can affect future employment, travel, etc. 93 days in Michigan, like 10 days. I would be surprised if they gave him 364 days. This particular offense, from what I've seen of the video that's available, his behavior, his demeanor, everything the police observed, he was rather calm. He was rather calm when he was engaged with police officers, and so that might. I don't think the police observed anything, is what I'm saying. I think it's just going to be witnesses, and it might be a he said, she said, or he said in this case. I missed the poop trail story. I missed that. I'm not sure I want to know right now. Megan texted me that he shared that, so that was crazy. All right. All right. Let's keep an eye on the court because we're supposed to be starting any minute now. If you guys want to watch as well with me, I'm on YouTube. Let me show you the page that we're watching for this court. This is the Thurston County District Court number 4. There are 4 courts, and we're in court number 4 for this trial. There are 3 videos showing here. The first 2 were just like preface. Like one of them, they talked actually about Mr. Farag and about how he no-showed, but it was actually this trial that was getting set up, or they were setting up for yesterday. And then we had the jury selection. That's what we watched. So the first 2, or the other 2 are like super short. So these first 2 are super short, and then we had the trial we just watched. At least the first half. So we'll keep refreshing that page if you guys want to watch and let me know as well. That would be wonderful. Hopefully you had a great lunch. I opened a new jar of spicy maple bourbon pickles, and for those who are new here, I haven't talked about these very much. But if you like pickles and you have not tried spicy maple bourbon pickles, which do not sponsor the show, sadly, to my great chagrin, the pickles will change your life. They're available at Walmart and I think at a couple other stores. They used to be sitting right next to the spicy habanero mango pickles, which were awful. And I sent an email to Walmart and said, these are disgusting. No one should eat these. And they pulled them from the shelf. So clearly they were reading my email, but they did not read the email where I said you should sponsor the show and send me free pickles. Anyway, I opened a brand new jar of spicy maple bourbon pickles that I'd been chilling in the fridge overnight. They were really cold. I ate about half of the jar, just fork to mouth, is right out of the jar. That's how it's safe to do that with pickles because there's like no germs. And it was, oh my goodness. They're a sandwich pickle, so it is a sweeter pickle, but it also is a spicy pickle, a hot spicy pickle. And they will change your life. They really will. They're that good. So if you're in the mood for some life-changing food, those pickles will fit the bill quite perfectly. See, I finally got a jar. The Walmart worker stuffed the bag too full, and the jar fell and broke when I got home. No, Tisha, no. That is a crime. That is a crime. Oh, my goodness. I am sorry. Link for the pickles. It's just Walmart, Sunny Moon. I don't really have a link. I guess I might be able to pull them up. Walmart. It's top shelf. They're top shelf food. Spicy maple bourbon pickles. Sam's Choice. Here we go. Let me put these up here. Copy paste. No, and I wish Walmart sponsored the show, but they do not. Only the pickles. There's very little else I recommend at the store, but the pickles I will definitely speak for. So there you go. That's the link that will get you to Sam's Choice, which is the brand. It's a Walmart brand, and they're really, really good. All right. It was actually pickles and not the cat. No, it's real pickles, I'm saying. Real pickles I ate. Real cucumber pickles. Cats don't like cucumbers, apparently. It scares them to death. If you like set a cucumber behind them while they're eating, when they turn around, they think it's like a snake or something, and they jump. At least that's what YouTube has taught me. All right, going back to court. Any moment now. I think we're starting right at noon, so figure we'll keep an eye on that. Got my nephew a great car seat from Walmart, $75 cheaper than Amazon, and the distributor, no regrets. Yeah, I'm all about getting a good deal. I really am. Since we just had Black Friday, I'll share this story with you guys. There was a Black Friday deal at Walmart several years back, where this was when like the iPad Mini had come out, and they had this special on the iPad Mini, and it was like, I don't know, it was like $250 for the iPad Mini, which was $50 lower than normal. And then they also had like a $100 gift card that came with it. It was this massive, it was one of their doorbuster deals. And so I stood in line and I got them, and I ended up, there was a mistake and I paid for it and they had to ship it to me or something, and they sent me 5 instead of 1. Like they sent me a case of iPad Minis instead of 1 iPad Mini. And then they did the same thing on the refund. Like they double gave me the refund. Once they gave it to me while I was there, and then they also emailed me the refund as well. So I got like a cash back, and so they gave me extra money, and they gave me 4 extra iPads. And so I opened the box. I'm like, this is a big box and it's heavy for 1 iPad. And I open it, and I've got 5 brand new iPads. And so I call up Walmart, and they're like, well, you've got to go back to Walmart and talk to them. So I go to Walmart and I stand in line, because apparently after Black Friday, everyone stands in line at Walmart. And so I stand in line for a long time, and finally get up to this customer service desk, and I'm explaining to them, I'm showing them a receipt and trying to explain how this makes sense. And they're looking at me like I'm from Mars. And they look at it and they're like, oh, here's the problem right up here at the top. You're at the wrong store. You need to go back to the store that you were at where this happened. Well, I had traveled to be with family and friends, and I was actually shopping with them. So I had to travel to the other store all the way down there and stand in line for again, and go through this whole process. And I'm trying to explain what happened, and they're looking at it and like, oh, this is something you'd have to call corporate on. And so I ended up calling corporate, and they're bouncing me around. Oh, we'll get back to you. They don't get back to me. I call back again. I explain the story. Back and forth and back and forth. I finally got high enough on the chain, and I explained to someone where he was able to verbalize back to me that I got twice as much cash back as I was entitled to, and I got 4 extra iPads that I had not paid for. And he said, you know what? We don't have a system where we can take those back in the inventory, how I can fix it. So appreciate your honesty. Just go ahead and keep them. And I'm like, well, what about the extra cash, the extra gift card, $100 gift card? And I'm like, yep, it's fine. Just keep it. I'm like, all right, look, all I can say is I tried to do the right thing. I tried to give you back these iPads, and they wouldn't accept them. So I ended up selling them. I made a killing. Gave one of them to my wife. So bank made an error in your favor. Collect $200. Pass go. Sometimes RA has a memory of a goldfish, and sometimes he has the memory of a bee. I've won the internet over 10 times. Goldfish apparently do have a good memory. I have not pulled your record, Adam. I have records on all of you about how many times you've won and who won and what the circumstances were of the win. I have all those records. It's just saved in video form. I have not like spelled them out and collated and everything else. I do that often. I do. So you donated it to the Boys and Girls Club, right? Greeners, that's a great idea. And I wish I could say I did. I instead donated it to the Fund My Personal Interest Club, which is similar. I imagine it's similar to the Boys and Girls Club. But Red Pen, I've only won 3 times. Oh my goodness, Little Miss. One more story about mistakes. Also, this was probably 7 years ago. We started buying on Amazon, and I was an Amazon seller and I still am. I guess I'm an Amazon seller. I've been there for 15 some odd years. I've sold on Amazon, and usually I buy and sell books, used books. Haven't done that in a while. My account's still open. I just don't have anything on it. And we were buying for Christmas. We're getting everything ready, and we bought I don't know what it was, some art kit, right? Like a kit of stuff, and it shipped from what's called a third party. It was a third party seller that ships FBA Amazon. So fulfilled by Amazon with a third-party seller. For those that don't understand, that means there's an outside company that is selling through Amazon, and for convenience, Amazon holds it at their warehouse and sends it when it ships. But the items belong to this other company. Sort of like me. If I was selling books, the items belong to me. I could ship them to Amazon, and they hold them until the person buys them, and then they ship them out. So I got a case instead of one. Once again, this was from Amazon this time. Of these art packs. Were like $50 art kits. And I call up Amazon, and they're like, oh, it's fine, don't worry about it. Just go ahead and keep them. I'm like, wait. Because I'm a seller, I know that third-party seller will just be told that, hey, your inventory's off. You thought you had 5 items, and you only had 1. And so, sorry. And they would lose it. And I called and complained, and I reached out to the seller. Okay, I found the seller and reached out to them directly and said, look, Amazon's trying to screw you because they're just telling me to keep these items that I have not paid for that did not belong to them. They were yours. And anyway, we were able to get them back. And Amazon said, yeah, sorry. Yeah, we'll send them back. Anyway, that's it. Okay, so let's see if court's going to start here soon. We are at 12:04. I'm not seeing anything yet. We'll keep an eye out for that. RA, can you do my shopping? If you want 5 of something instead of 1, apparently I'm the person to go to. Let's see. Let's see. I ordered a 16 count of AAA batteries on Amazon. I received 16 packages of 16 count AAA batteries. That warehouse worker saw 16 and packed it up. Oh my goodness. Lifetime supply of AAA batteries. Lizzie, oh my goodness. I guess the robots make mistakes sometimes. Let's see. I have 5 kids, so that did work. I've got 6, but usually they don't all want the same gift. Oh, we have live court. Let's go ahead and jump to it now.
What's that? Okay.
And Your Honor, I was going to actually ask if I could move it during my...
You can put it wherever you like.
We're going to back up 30 seconds.
Asking if it could just be a little left or a little right.
What do you mean?
The podium?
The podium, I'm sorry.
Oh.
It's just right in the middle of everything for me.
Yeah, that's just, we're not going to, we're going to leave the podium where it is.
Speed up until we're caught up.
Yeah.
Curious request.
What's that? Okay.
And Your Honor, I was going to actually ask if I could move it during my...
You can put it wherever you like. And both counsel can put it wherever they like, wherever they're most comfortable.
Okay.
Mr. Fortunato.
It's come to the city's attention that one of our witnesses did accidentally go into the juror room and did, I believe, have a limited conversation, no conversation with any of the jurors, but did walk into the juror room. I believe it was a short encounter. Corey may be able to give more information on that. I know he had the chance to speak with the juror, and I believe it's been addressed, but we did want to make that aware of the court. Counsel.
Mr. Thompson?
You had a
the witness indicated to me that he walked into the jury room not realizing it was a jury room, was looking for his name and saw on the paper juror and realized he was in the wrong room and immediately left.
Okay. Thank you. Defense have any comment on that? I'm not sure what to, if there was no interaction or... Do you know how many jurors were in the room when they
moved for mistrial?
Based off when I saw the witness after he left the jury room, I would say at least 5 of the, I guess 6 of the 7, I suspect, because there was one juror who was not in the room, and they actually passed each other in the hallway when he walked up to me and approached me to tell me about what had happened. So,
Ms. Rowe.
Hang on. A juror walked up and told him?
The jurors actually engaged in conversation, what the conversation was about.
Well, we can bring your witness in. We'll find out from him first.
Okay. And there's going to be another issue that I'd like to address too, Your Honor. I'm not sure if you want to do it now.
Yeah, well, you could let me know what the issue is.
Your Honor, my client has a website, a YouTube channel, and he received a message on his channel, a comment on his channel for is it this when it happened? 39 minutes ago?
No, it was about an hour ago.
About an hour ago. Could we address this outside of the witnesses?
Okay. First of all, let's handle this.
Okay.
So go ahead. What's your name, sir?
Samuel J. Kirkley.
Okay. And then I'm told that you, for lack of a better term, wandered into the jury room.
I was being an idiot.
Well,
and when I realized my name wasn't down, I just walked out. Didn't talk to anybody. Didn't even talk about the case. Nothing. I walked in. They said their names were on the paper. When I realized my name wasn't on the paper, I kind of connected 2 and 2 and then felt like an idiot because I was a witness and not a juror.
Okay. How long were you in there? Were you even in there for a minute?
Maybe 2 or 3. I mean, I walked around the desk.
10 tops.
Looked for my name.
Okay.
When I realized my name wasn't on any of the papers, didn't have a conversation.
Did anybody say anything to you, or?
I just said, they said your, name's on the paper. So I looked at the paper, went around.
I see.
The case wasn't discussed. Who I was, who they were wasn't discussed. I saw 2 names and I couldn't tell you who they were because I was just looking for mine.
Okay. Hang on just a second.
Yep.
Ms. Rode, and again, I have not sworn you in. It was just having a conversation. Do you have any questions? Do you have anything you wish to ask him?
Were there any comments made by the jurors indicating they didn't know why you were there, or?
No, they just said, we found our name on the paper. Like the jurors found their name because it was in a big desk and there was a badge or, a number, juror number sticker and their name. When we realized once I connected the dots, then I realized I'm not a juror. I'm a witness. I should have known better.
So when you say that someone in there said, we found our names on this list, was that in response to you asking a question?
No, I was just looking for it. And I was like, the conversation was short, honestly. I'm not a morning person, so I'm not really awake. But nothing, like I said, the case wasn't discussed. Who I wasn't discussed. I looked at 2 of the paper for the names. I didn't read below it. And then I said, oh, crap. Then I walked out realizing where I was, but yeah, I don't.
So they have 3 witnesses.
Nothing about the case was discussed. Who I was discussed.
2
who they
police
were
officers
wasn't discussed. This case, even the case
and
that
the victim.
they were all on wasn't discussed. So
could you point out the 2? Were there no? There was like 5 people in there.
3, 4, because there was 2 or 3 empty desks or seats with names. So I said, okay, no problem. One of these is mine. Then when I realized none of them were mine, I realized my mistake, felt like an idiot, and walked out and grabbed somebody, and they hooked me up with him. Put me in the right place.
We're about to be outed to the court, by the way. One of you went and chatted.
Do you have any questions?
No, Your Honor.
You can go ahead and go back outside, sir.
Okay.
On the defendant's YouTube page and said, hey, we're following you on RA's channel. I'm just calling it right now. One of you ratted us out.
Ms. Rowe?
Yes.
Do you have any? Again, my inclination is just. It doesn't appear to me that there was any certainly no intentional inappropriate contact.
This is why we
and the
can't have nice
contact that was
things,
made,
guys.
There was nothing
This is why we
inappropriate.
can't have nice things.
And
Is there any way we could confirm with the jury pool who might have spoken to the gentleman?
what's that? Well, we'd have to bring them in one by one. But, okay, so, but before we do that, if you want to do that, we'll do that.
You wanted to hear the issue that I was also going to raise?
Yeah.
Yeah, let's go. Let's go there.
So my client has a YouTube channel,
I have one of those too.
and about an hour ago,
Yeah, why don't you put your phone down there, sir?
well, I need to
I
read.
know you don't. If you want to talk to me, you can. And then if you need to consult with them before you talk to me, you can do that also.
Okay. He was showing this to me because he wanted me to read the post on his YouTube channel. But someone at Aussie Gardner 1773.
You're outed, Aussie Gardner.
Posted this on his YouTube channel.
It's your birthday too.
And thought I might enjoy your content. Just subscribed. We do not know if that is one of the potential the jurors that are there,
and that's nothing wrong.
You know, that one of our jurors or not.
Aussie Gardner, good job.
That post does raise some concern, and if the court, I would like to find out whether any of
They
these
think Aussie
jurors,
Gardner is one of the jurors. Aussie Gardner, you made it into the court record.
I'm not all into this YouTube stuff, but that name is, what did you call it? It's a handle, I guess it's not their email. It's kind of like their moniker, but it's very concerning that says, saw you in court and thought I might enjoy your content. Just subscribed.
One of us.
It says just subbed, and Mr. Farley indicates that means subscribe.
And he's not used to having new subscribers.
Would object. Sorry, excuse me. The city would object that there's no indication in any of that statement.
Okay, so hang on, just okay. So yesterday, I instructed the jury not to do any research, do any engaging in any social media. YouTube's not social media, but I'm going to assume that I presume that they follow those instructions. That handle that you mentioned, that's meaningless to me. We are also streaming. All this is live streamed. Yes. And so and I know just from my own experience, a number of people follow court on YouTube quite frequently. And so when someone says they saw him in court, that could be anyone, anywhere watching this trial. And so I'm not going to inquire as to the
okay, so none of you go sending him messages because he's going to read them during court.
I'm not going to.
Oh my goodness!
Bring these jurors in and ask if you subscribe that. If subsequent investigation shows otherwise, but I even used the example yesterday about how someone was posting. I think I did anyway. Posting on a social media website from a jury room. In some case, it had to be returned. I said, "Don't do that." And so I'm not going to, again, without more, I'm not going to quiz these jurors on that. And with regard to the other issue, I'm going to reverse myself a little bit, and I think we'll bring them all in at once. And then I'm going to ask, I'm going to mention someone walked into the jury room. Did anybody have any conversations about the case? If anybody raises their hand and says yes,
this is live. This is happening right this moment.
They'll learn that who the person walked in was a witness when that witness is called. But if they have any conversations with that individual, I will say someone did walk into the jury room. He walked out. I'm told it was for a short period of time. Was there any discussion about the case with that individual who walked in? And somebody raised their hand, then we'll send the rest of them out, talk to the people who raised their hand. If they say no, it was just incidental, harmless contact, state can call its first witness and we can go forward.
Thank you.
Now I know he's reading his comments. Just posted RA Clan watching, hoping you get a 10 stretch for being a public nuisance.
Objection to that course of action.
None, Your Honor.
All right.
Oh, he has screenshots. He has like screenshots or printouts. This is video printouts.
You can bring the jury in.
It's nice that he reads his YouTube comments. That is really good. I would recommend that no one do anything in any way that would cause any sort of problem in this trial. As always, that is my recommendation. I have respect for the court and the court system, and so we would ask that no one do anything that would cause problems there. But saying, hey, like your content, just subbed. I subbed as well. I'm just saying. So there's no problem there.
So I don't.
Ozzy Gardner, we have to talk. I want to know what it feels like when you suddenly hear your name read in court. What it feels like for you, because I've been there. Oh my goodness. Yes, lots of people subbing. I think. Let me check his channel. Where are we at on that? Let's see. Let's keep that on. Where are we up to? I can barely read this. Let's see. Refresh. Oops. Where's my refresh button gone? There it is. So he was at 9.12, and we've now brought him up to 9.14. So we've had at least like 40 people. At least 40 people have subscribed to his channel. His YouTube channel name, that's right here. It's Pacific Northwest Transparency, and he has this little frog, a little cute little frog icon. I'm not sure. The snake and the frog. The snake eats the frog, but he's the frog. I don't know if there's meaning behind that or anything else, but know your rights or you have no rights. That's sort of his motto, and that's where we're at. So if you want to follow, please don't do anything that might disrupt court in any way or cause him to think that court has been disrupted. We want everyone to receive a fair trial, no matter what they've done or charged with.
Good morning, members of the jury. Welcome back. Sorry for the delayed start. But here we are getting started. Before we get started, I just want a couple of housekeeping things. First of all, I think I forgot to mention yesterday that while we're in session and trial session, the clerk is going to keep your phones. And then so we're not trying to, if you need them during the break, you contact someone. Of course, you can have them. You'll have them over the noon hour for lunch and things of that sort. We just keep it away from you while we're actually in session to avoid the distraction. So I forgot to mention that. I'm sorry about that.
Victoria, this is happening live.
Second thing
we're
I want to
streaming
mention
it live.
is, we do take breaks periodically in the morning. Sometimes we don't take them often as people would like or need. If at any time anyone ever needs a break, just get my attention, wave your hand, say, excuse me, we just have a quick break. And then I'll certainly allow that. So there's that. Third thing I want to mention, I am told that before 9 o'clock, before you came into court, someone not on the jury, for lack of a better term, wandered into the jury room. And I don't know if you had any contact with that individual. Did anybody have any conversation or contact with that individual who walked into the jury room, or have any sort of conversation at all? I will tell you that person is going to be a witness, and I just wanted to make sure if anybody had any conversation with that person. I'm told he walked in, looked a little bit, realized he was in the wrong place, and then left. But there was no conversation of it. Yes, ma'am. Okay.
She talked to him. There was conversation.
And then left. Okay. Any
I'm not encouraging it. I'm dead serious when I say don't do anything that would interfere with court. I have I hold so much respect for the court system.
Fortunato, you may call your first witness.
Thank you, Your Honor. Your Honor, the city would first like to call Officer Peter Navaro.
I'm serious. Don't do anything that would cause problems. There's no problem with subbing on someone's channel and saying, hey, like your content, I subscribed. But don't do anything that would indicate that you would be a juror. And Ozzy Gardner, you did nothing wrong. Your message was just fine. The judge is not even concerned enough to ask the jury. There was nothing wrong done there.
Do you swear to affirm the information or testimony you provide will be the truth, the whole truth, and nothing but the truth? Yes, sir.
We should get a witness camera here soon. Just a second.
I'm just going to say one more time, because again, we're all spaced out in this facility. Anytime you can't hear anything from either an attorney or a witness, and I'll say this for all the witnesses, please let me know, and I'll have them speak up. Mr. Fortunato, you may inquire.
Good morning. Could you state your name for the record?
Peter Navaro.
And would you be able to spell that for us?
Yes.
P-E-T-E-R-N-A-V-A-R-R-O.
And what is your occupation?
I'm a police officer with the city of Tumwater.
How long have you been a police officer?
Since March of 2018.
What kind of training did it take for you to become a police officer?
So I attended the Washington State Criminal Justice Training Commission.
He needs to turn the podium.
BLIA, or Basic Law Enforcement Academy, from July through November of 2018. That consists of 720 hours of course material where we learned about criminal law, patrol tactics, application and execution of search warrants, processing and handling of evidence, driving under influence, RCWs, and things of that nature. And it also included unarmed self-defense and firing ranges and things like that.
And you said this was at the academy that you learned this?
Yes, sir.
And have you had any training additionally after graduating the academy?
Yes, sir, I have.
Okay, could you go into a little detail about that?
Within the department, we conduct training periodically about every other month, 6 times a year, where it is department-based training where we go and reinforce the same teachings that we learned at the academy, and just kind of expand on it and stay current with current case law, and making sure that the practices that we are enforcing out there within the community are within case law and current standards as well.
Have you had any specific training on assault investigations?
With what I received over at the academy, understanding the RCW, and then with outside of that, I've taken some other training when it talks about responding to critical incidents, but that's it wasn't very specific to assaults. It was more to a bunch of different crimes.
Have you ever conducted an assault investigation?
Yes, I have.
Would you say about how many, ballpark, if you had to guess?
That's in the hundreds.
Hundreds, okay. In your duties as a police officer, do you often interact with security guards?
Yes, I do.
And kind of in what capacity do you interact with security guards primarily?
They're either usually a good source of information for incidents that are happening within that particular area that they're protecting, whatever that building or department store, whatever the case may be. I've also interacted with them as far as them being able to identify potential suspects of crimes that have occurred within that area.
Okay. So now I want to talk to you a little bit about the incident. Were you on duty as a police officer on July 20th of 2023?
Yes, sir.
And what were the hours of your shift that day? Do you remember?
That specific day, I don't remember, but I usually work the 0500 or 5 a.m. to a 4 p.m. shift.
Okay. Do you remember being dispatched to the Department of Social and Health Services office in Tumwater that day?
Yes, I do.
And what had reportedly occurred that day?
The initial call came out as an assault in progress within DSHS.
And where is this DSHS office located?
Just north of Israel Road on Capitol Boulevard, about the 6800 block, I want to say.
And in what city is this located?
Tumwater.
In what county?
Thurston County.
In what state?
Washington State.
Were you the only officer to report to the DSHS office that day?
No, I was not.
What did you observe when you arrived at the office that day?
Upon arrival, there was a witness or a gentleman that was outside that had already started giving some information, and I asked that gentleman to just kind of stand by until we figure out exactly what was going on. He kept on pointing towards the inside. I was also met by a security guard outside, and at the same time, that's also when I met Mr. Farley that was standing outside, and I recognized him from previous incidents.
Objection, Your Honor.
Okay, I'm going to sustain the objection.
Sustain
I'm
objection.
going to instruct the jury to disregard the answer just given. And you may ask your next question.
Can't say previous. Good catch on the objection.
Yes.
Move for mistrial. Move for mistrial. Do it.
And that answer will be stricken also.
Thank you, Your Honor. Your Honor, if we could have a sidebar.
Members of the jury, we're going to take you, sometimes we have breaks when we don't anticipate them. This is one of those times. And so you're going to be taken back into the jury room for just a second. This shouldn't be too long. And then we'll be brought back in when we're done here.
Okay, this is a 403 issue. The witness was asked by the defense if he recognized, or basically the lay of the incident, and the witness, the police officer, says he recognized the defendant, and he's like, "How do you recognize him?" And he's like, "I recognize him from previous incidents, and previous times have been called out to him. We know this guy; he's well known to the police force."
One of the issues that was specifically addressed yesterday in motions in limine.
It was.
And the court's ruling on that was that the court was going the court granted my request that the officer not reference any prior incidents that he may have, or occasions that he may have dealt with Mr. Farley. The reason for that motion in limine was to prevent the jury, was to protect my client from jurors assuming that prior content with my client was of a criminal nature. I'm surprised that wasn't relayed to Officer Navaro, but I would be moving
for mistrial. Say it. Just spit it out.
For a mistrial.
Boom. There it is.
Mr. Fortunato?
Your Honor, you clearly stated that this is something that's going to be stricken from the record. As is mentioned in every jury instruction, you are not, and the jurors have been reminded several times, do not regard any information that was stricken from this court. I think upon a limiting instruction in that regard, what's already going to be in the jury instructions, this is not something that needs or nearly rises to the level of something that would cause a mistrial to be warranted. You've made it clear to the jury that this is something that they are not to engage with, not to entertain, and this is not something that is going to derail this case. So the city strongly opposes defense's motion as it is improper and there is no adequate basis for it.
What about your duty to inform the witness?
Yes, I share Ms. Rowe's concern that this was litigated pre-trial in that this specific issue, these words were, she made a motion in limine to keep that out. That was granted. We talked about whether or not identification, and that maybe could be brought back in if identification became an issue. So I'm pretty concerned about that. That wasn't discussed with the witness beforehand, apparently. But on the other hand, I don't think this rises to the motion for mistrial is going to be denied at this point. I did instruct, I sustained your objection. I instructed the jury to disregard the answer. And I don't think that even though that has been heard by the jury, I don't think that's so prejudicial to warrant a mistrial at this point. So the motion for mistrial will be granted, but again, as I said, the objection was sustained. I've already stricken the answer, instructed the jury not to regard that or to disregard that. That's also included in all final instructions. They'll be instructed not to disregard anything that I have stricken and asked to be removed. So they'll be instructed on that again during final instructions. But that's a long way of saying that the motion for the mistrial is denied at this point.
And Your Honor, if I could just make a record, I do, it's our position that there are things that are said that can't be unheard, I believe that the opportunity for prejudice outweighs the probative, and I believe that Officer Navaro's testimony contained inadmissible matter, so I would simply like to make the record for that.
Sure, and
So
I
that's
agree with you
preserved
that
for appeal.
it was an inappropriate answer and in violation of the motions in limine. I'm just saying it doesn't rise to the level of a mistrial at this point, and you've made a sufficient record in that regard. And we can bring the jury back in.
And Mr. Prosecutor, you're welcome to turn that little
Before
lectern.
we bring in the jury, Your Honor, may the state potentially at least take the opportunity to inform Officer Navaro regarding the court's ruling with the motions in limine?
Yes, I would hope that he has gotten the message at this point. The issue was whether or not Mr. Farley had been recognized with previous contacts. I ruled that wasn't to be mentioned unless certain things happened, and now it was mentioned, which is why we're here now. So don't mention that.
Yes, Your Honor.
And then with that, you can bring the jury back in and let the other witnesses. Apparently, there's another police officer, or is he?
No, he won't be called, Your Honor.
No, he says.
Okay.
No.
Thank you.
Jury can come back
There's
in.
no way we're calling that other guy. All right, so we narrowly avoided mistrial. It was a very timely objection, and the way she preserved for the record for the appeal was properly done, a bit haltingly, but properly done. Good work on the defense attorney's side.
Mr. Fortunato, you may ask your next question.
Thank you, Your Honor. Pardon that delay. Officer Navaro, could you describe the layout of the DSHS office, kind of briefly, what the layout of the place looks like?
So the building itself is a multi-storied building. On the first floor, when you first enter, there's actually 2 points of entry. There's, I would say, the north entrance, and there would be an east entrance is the way that I would describe them. If you were to come in through the east entrance, it's a long hallway or passageway that leads you to the elevators. And then at the very end, it leads you through a set of double doors on the left-hand side that take you into the DSHS area. There's bulletin boards, informational packets that are up on that in that long hallway. If you were to come in through what I said would be the north entrance, that goes directly into the lobby area, the public entry for DSHS for anybody that needs to conduct business in there.
Okay. You said you weren't the only law enforcement officer.
Where is he?
On the
Where's
scene.
Mr. Farrell?
What did the other law enforcement officers do when they arrived? Or I guess when you arrived, what were the other law enforcement officers doing at the scene?
So I had one officer that remained with me, and then another officer that was Detective Bowling that went, eventually he went inside to go speak with the parties involved and any other witnesses.
And you said you were outside. Did you observe any other patrons present at the DSHS office?
I did. There were some that were inside of the lobby area, and then a couple of them that were walking in and out. And that same gentleman that I had initially contacted was standing off in a distance, just kind of waiting, like I asked him to be contacted by another officer.
And did you remain outside for the duration of your investigation, or were you inside and outside?
No, I primarily stayed outside.
Okay.
Detective Bowling was inside.
So what did you do after arriving at the DSHS office in Tumwater?
Upon arrival, I had contacted Mr. Farley and essentially went into trying to figure out what exactly was going on. I had advised him that our interaction was being video and audio recorded. And then that's when he had given me his statement of the reasons for the call, which was later relayed to Detective Bowling.
And I'm going to cut you off here a little bit. You said you spoke with an individual and you described him as Mr. Farley. Is that individual in this courtroom right now?
Yes, yes.
Would you be able to point him out by describing an article of clothing to me?
Sure thing, sir. He's currently wearing a black shirt with glasses and I believe tan pants and boots.
And Your Honor, let the record reflect that Officer Navaro is pointing to Mr. Jeremiah Farley.
It will.
That's the defendant.
What was Mr. Farley's demeanor when you were speaking with him?
He was conversational with me, as straightforward and direct as one could possibly be when interacting with a law enforcement officer, telling me exactly what had occurred
and
from his perspective.
What was his facial expression?
What was his facial expression? He sort of did a...
If you can remember.
No, reenact it.
Yeah, from what I can remember, he was...
Looked a little like...
Yeah.
And then like...
I wouldn't say that he was mad or aggravated, but he definitely had a look of concern as to what had taken place.
Okay. And what was his tone of voice when speaking with him?
Again, very direct, very straightforward and to the point.
And what was Mr. Farley doing when you arrived at the DSHS office?
He was exiting out of the DSHS office when I encountered him. He was walking east down the little small corridor. There's like an overhang with some pillars, which is where I had interacted with him. And it's a very short period in time there from the time he exited to when I started talking to him.
So you said you spoke with Mr. Farley. What did he say to you?
He had told me that he was inside of a DSHS, videoing, recording what the business practices were inside of the building. He told me that it's a public building, that he had the right to be inside of the building recording its daily activities, to which the security guard had.
And I'm going to stop you right there. Did he mention having an appointment with the DSHS office that day?
No, he did not.
Okay. Did he mention anything about being with someone else or if he was on his own that day?
He told me that he was on his own. There was nobody else there present with him.
And what did he say happened? He said he mentioned that he walked in and was recording. What did he say happened next?
He told me that he had walked in through what I had described as the east entrance, or I'm sorry, the west entrance, now that I'm thinking about my directionals there. He had walked in through there, was going down the hallway, again, recording the day-to-day operations, what takes place within the building.
And did he mention why he was recording?
He says that it was, he's a freelance reporter, a freelance reporter that was capturing footage for what's take place in the public buildings.
Okay. To your understanding, was he allowed to record in the DSHS office?
Within the DSHS office itself, there are some signs that says that there's no recording or videotapings that should be taking place. I also understand the right of being able to record in public spaces and in buildings as it sees fit. But my best of my knowledge, within the DSHS building, they have, because they deal with people's personal information and it's discussed out in the lobby, they're not to be recording in that area.
So you said he walked into the office and he was recording. What happened after that?
The security guard, from what Mr. Farley had told me, had approached him, had told him to stop recording, that recording was not allowed. There was a verbal exchange between the two gentlemen. At one point, from what Mr. Farley had described to me was that the security guard had encroached into his personal space.
And I'm going to stop you right there. Did Mr. Farley say anything about him discontinuing his recording after being advised that it wasn't allowed in that room?
No, he told me that he was still recording.
And did he mention why he continued recording?
He believed that it was his right to record within that public space.
Okay. And you can go ahead and continue. I apologize for interrupting you.
So when the security guard approached him, Mr. Farley had told me that he had encroached into his personal space, causing him to just kind of back off a little bit, telling him to step away from him, that he had a right to be recording. There was a discussion or verbal altercation between the two of them.
And you say there was a verbal altercation and this discussion occurred. Did Mr. Farley mention where within the office this discussion occurred?
It happened in the hallway leading through the double doors, as he was walking through the building.
And you say these double doors, where did these double doors lead into again? I know you had mentioned that, but I want to be clear here where that is.
They lead into the DSHS lobby where the public is conducting their business and their information is being discussed.
Did he mention anything about other patrons being present in the office at the time?
Yes, he did.
Okay, go ahead and continue.
So, while this took place, it happened, like I said, at the double doors leading into the DSHS office. At some point during this altercation, it became a little bit, it became on the physical side between Mr. Farley and the victim. And then that's when I believe other patrons within the lobby started becoming upset at what just took place.
And you say they became upset. How was that known? Did Mr. Farley describe any manifestations of that anger?
He told me that there were other people that were yelling at him within the lobby. He said that there were telling him to leave, that they shouldn't be recording in there. It was nothing physical. They were all at a good distance from him, yelling from across the room. I'd probably say the lobby is about maybe half the size of this room, maybe a little bit larger, but excuse me. They were just kind of yelling at him, telling him to stop, to leave the security guard alone. The security guard at one point broke contact with him. I believe his supervisor came in and took him away, from my understanding of it.
So you said that there was a physical altercation between Mr. Farley and the security guard.
Correct.
And this occurred after the argument between them.
Correct.
Did Mr. Farley mention to you anything about the security guard's reaction to that physical altercation?
He told me that he was obviously upset. He had taken a couple steps back. I believe there was some chest bumping that was happening between the two of them, some shoving that occurred. And again, this all happened right there at the entryway, kind of like the cusp between the hallway and the DSHS lobby.
Was Mr. Farley recording while he was speaking with you?
Yes, he was.
Did your office attempt to retrieve the recording of the events that afternoon?
From
Mr. Farley, yes.
Yes, we did.
And how so?
Where's the video?
In the course of our investigations, knowing that he was recording, I had asked if he could show me the video, to which he declined. Later on, as the investigation progressed and probable cause was established for Mr. Farley's arrest, we ended up seizing the video camera along with his cell phone. That way we could apply for a search warrant and obtain the video based off of the belief that there was some element to the crime that would have been captured within that video.
And you were saying throughout this encounter, Mr. Farley was recording the event. Was this just on one device, or what was the, I guess, device that he was using to record, if there was just one?
There were actually two devices, to the best of my knowledge, which were the two that were seized. One being his cell phone, which I saw him holding on with his hand, and the other one was it's a body-worn camera.
It's a GoPro.
I believe it's a Boblov, or it's almost like a GoPro type camera that he had on his backpack satchel type.
And you said there was a search warrant that was applied to get the video within these devices. Was that eventually accomplished?
Yes, it was.
And so you were able to retrieve those recordings?
Yes, I was.
At any point, did Mr. Farley deny to you intentionally touching the security guard?
Mr. Farley said that he had done all that he can to defend himself. He felt that he needed to defend himself from the security guard based off of his actions. But then that's when the security guard left and he ended up taking off. Without rereading my report, I can't remember specifically if he had said whether or not he had pushed them back or not.
When are we going to break for lunch, Judge?
Thank you. Your Honor, I have no further questions.
Thank you. Ms. Rowe, you may cross-examine.
Okay, they just had the... is she going to do it from her seat? They just had their only police officer witness testify, and there's no evidence of a crime.
Good morning.
Officer Navaro, you indicated that you have been with the city of Tumwater for about 5 years. Is that correct?
Correct, ma'am.
Yes. Okay. So
I want to.
You come to the panel, to the podium, and you can speak a little louder.
Thank you, because we couldn't hear either. Bring all your papers. There's room for everything. Bring it all. Okay, your client's not going anywhere. You can even move that and turn it to face the witness if you'd like. There we go.
Move this aside.
I was kicked back, taking it easy.
What are you doing? What?
I will speak louder.
She got all the way up there just to move the lectern, and now she's going to yell. Yell from the back, from her chair. Nope.
Are we going to address subject matter jurisdiction?
Let's move it again, because now it's in the way the other way. Let's can somebody help her move this out into the hall? Let's move the TV, the printer. Let's just shuffle the whole courtroom. If we could move the jury box to the other side, that would be more convenient. There we go. All right. Coops, thanks for gifting 5 memberships. She just moved to the microphone.
So, Officer Navaro, you indicated that you have been with the city of Tumwater since 2018. Is that correct?
Yes, ma'am.
And you also indicated that you received assault training.
Like how to?
What is your understanding of what an assault is?
It essentially means that it's any
objection, Your Honor. That calls for information that wouldn't be known to this witness.
That's sustained. The jury's going to be instructed on the law.
Calls for a legal definition.
Question, Ms. Rowe.
A legal explanation. I don't know. What's the word there? Officer doesn't know what assault is. That's what we know.
So you indicated that you were dispatched to DSHS, and the dispatch indicated that there was an assault in progress. You also, is that correct?
Yes, Your Honor. Or yes, ma'am.
Legal conclusion. Thank you, Reverend Beasy. Appreciate that. And thanks for running 3 miles for
me. You described the office layout.
Mr. Farley was triggered by her chair being out of position.
Yes.
Tell you what, you just stand wherever you want, and we will we'll just deal with whatever you give us, ma'am. Thanks, Greeners. I didn't quite feel the benefit of the 3 miles that Reverend Beasy ran for me, so that would be why. I would say this lawyer has a slower style, but she's been on it when she needs to make an objection. It's been very slow in like forthcoming, but it was timely, and that's what's important. She did the right steps. As far as the record's concerned, she's batting perfectly right now. What is that, batting 1,000? She's doing a good job.
That's Exhibit 1, Exhibit 2, and Exhibit 3.
Everybody gets pictures.
Do you recognize the what those pictures are of?
Yes, ma'am, I do.
And what are they of?
The DSHS lobby.
And do they look to be where the incident occurred that day?
Yes, it does, ma'am.
And what's been described as Exhibit 1, is this the east entrance that you were referencing or the other entrance?
This appears to be the north entrance.
And bring your attention to what's been marked as Exhibit 3. Is this the east entrance coming in from the hallway that you were referencing?
Correct. That is the entrance that comes in from the hallway. And I believe I mislabeled that earlier. I meant to say it's the west entrance.
Okay. Thank you. Publish these to the jury.
Well, are you asking to have them admitted?
I am asking that.
Any objection to the admission of the 3 photos,
No,
Mr. Fortunato?
No, Your Honor.
Okay, they will be admitted, and yes, you can publish them to the jury.
Thank you.
Handouts for all the jury now. We get to see the entrance to the building. Oh, we don't, but they do. I believe she's a public defender. The way she introduced herself, saying she was a defense attorney in this county or something. I think that's something about the way she introduced herself to the jury during voir dire makes me think she's a public defender. Could you have asked what the officer's understanding of an assault is? I think you probably could. Because at some point the officer has to make a legal conclusion when they're arresting and charging someone. They have to say determine what charge they're going to press against the individual. So I think there's probably some aspect of that they could get into without crossing to that legal conclusion line. You see him keep looking down at his phone. I hope nobody's texting him. Don't do that. Don't text him. Vicky, I was surprised that the state, or I guess the city here on the prosecution, rested with this witness without ever getting any evidence from this witness that a crime occurred, as this was an arresting officer. And apparently the other officer who went inside, who might have had more knowledge about some of these aspects, has not been called as a witness. So they're going to arrest it entirely on the victim and maybe bystanders. Yeah, I can tell you, Sheila, you're right. This gentleman's YouTube channel is generally not going to be of the size where the views he's getting would amount to money he could live on.
So Officer Navaro, in your description of the office layout, do those pictures depict what you understand to be the DSHS office?
Yes, ma'am.
And do they also depict the 2 points of entrance? I believe you indicated that it's the east entrance and the north entrance.
Correct. Yes, ma'am.
And you indicated in your testimony that the east entrance was located in a long hallway. Is that correct?
Yes, ma'am.
And that hallway contains bulletin boards. Have you ever looked at any of the information that's posted on the bulletin boards?
I have in the past, yes, ma'am.
And you also indicated that there were doors, double doors on the left side. That was the left side of the east entrance that is part of the long hallway?
Yes, ma'am.
And you also indicated that when you arrived, you made contact with Mr. Farley. Is that correct?
Yes, ma'am.
And you advised that you were recording your interaction with Mr. Farley.
Yes, ma'am.
And was Mr. Farley also recording you during that contact?
Yes, ma'am.
Did you ask him during that time to cease his recording of your contact, of your interaction?
As in to stop it?
Yes.
No, ma'am.
Why? Because it's a legal protected activity.
It seems like you were recording him and he was recording you. Is that correct?
Objection asked and answered.
And when asked about Mr. Farley's demeanor, you indicated that he was conversational and straightforward in his answers. Was he polite?
Yes, ma'am.
Was he respectful?
Yes, ma'am.
And you indicated that his facial expressions showed concern. Is that correct?
Yes, ma'am.
Do you know what he was concerned about?
Essentially what had taken place within the DSHS lobby. He was obviously upset about the interaction that he had with the security guard, and the reasons why we were contacting each other at that point.
Yes. Was he calm?
Sorry?
Was his demeanor calm also?
Yes, ma'am. I would say he was fairly calm.
And you indicated that Mr. Farley, as part of your interaction with Mr. Farley, you indicate he told you that he was inside the department, the DSHS office, investigating or looking into their business practice and daily activities. Is that correct?
Objection, Your Honor. That was never. Facts not in evidence, Your Honor. That wasn't asked on direct.
Overruled. You can ask you may need to repeat your question, Ms. Rowe.
Did Mr. Farley tell you why he was there at the DSHS office?
Objection, Your Honor. Hearsay.
No, it's a statement of, well, yes.
It's overruled
no.
in that it's an admission by a party opponent.
But it's
also, you would interview, you would discuss with this witness statements attributed to Mr. Farley. And so given that you started there, Ms. Rowe will be allowed to continue. So you can answer that question.
Yes, ma'am. Could you repeat the question again, ma'am?
I don't agree with that ruling.
Do you remember Mr. Farley telling you that he came to DSHS regarding the business practices and daily activities?
Yes, ma'am.
Did that cause you concern?
No, ma'am.
Party admission is for the other party. It would be for the state to allow something in of what he said. For the defense to allow it in, they have him as a witness and he has to testify.
You also indicated in your testimony that Mr. Farley indicated that he was recording the day-to-day activities and that he was a freelance reporter of public buildings. Is that correct?
Yes, ma'am.
Did that cause you any concern?
No, ma'am.
Why not?
Good question.
Objection, Your Honor, relevant.
I'm going to sustain the objection to the last question.
Oh, man. I would have loved to have heard the answer. Because the officer has to say because it's a constitutionally protected activity.
You also indicated in your testimony that you believed that there were signs regarding recording. Is that correct?
Yes, ma'am.
Have you ever seen any of those signs personally?
I've seen them inside of the lobby. If you were to come in through a doorway that leads you directly into the lobby, they're right there off to the left, ma'am. Where there's some windows where businesses gets conducted.
So are the signs located closer to the north entrance or closer, or are the signs at the east entrance?
The ones that I was referencing are at the north entrance.
At the north entrance was the opposite side of the room as the east entrance?
Correct.
Are you aware of any signs around the east entrance?
Those signs wrap around the same windows where all of the business is conducted, and right next to the east window, right next to the east doors there's also a where everybody has all of their intake taken care of. That also shows a sign.
And you've personally viewed a sign at the east entrance?
If my memory serves me correct, I've seen them there before, yes, ma'am.
And they are inside the lobby?
Yes, ma'am.
Okay, so it's true that I am strongly on the defendant's side when it comes to his right to film in public buildings.
What's been marked as exhibits 1, 2, and 3.
I don't agree
Can
with
you
some of the methods they go about doing this, some of these First Amendment auditors. But
point to an area where you believe the signs are located?
With exhibit 1, it's not within view of that picture, but as I'm looking at it, it's off to the right of it where the windows all start.
Okay. And I'm showing you what's been marked as exhibit number 3. Can you indicate where you believe the signs were located? Around the east entrance?
If I'm not mistaken, I believe that I have seen signs in the past near this window where there's a kiosk there.
Do you know if you saw those signs there that day?
Not that day. I can't definitively say that I did or did not.
And if I could review what's been marked as exhibit number 2, are there any places where the signs would be located in that picture?
Right by where this lady is sitting at on the left-hand side of the photograph, and then by the empty chair on the right-hand side, there's some signs there that says no videography or taping or recording.
So if you could you circle what you believe to be the notices regarding video recording?
Your Honor, objection. This is an exhibit. That defense is showing this is not something that the witness should be highlighting or marking in any way.
Okay, overruled.
Could you circle where you believe these signs are in that picture? You indicated one was behind somebody.
Those are the 2 that I can remember at this time.
We all have the song stuck in our head now. Thank you guys for that. Signs, everywhere are signs. Do this, don't do that. Can't you read the signs? Yep. Where I grew up, signs were meant to be shot, apparently. You must be out in the country, hopefully. I mean, no signs should be shot, but I'm not condoning that behavior, but I'm hoping it didn't happen in the middle of a city. So now the jurors being shown where the circles were drawn on the exhibit. Yeah, unfortunately, my feelings don't come into play when it comes to somebody else's rights. And this is what this channel likes to cause. This gentleman's channel likes to cause that conflict, where other people's strong feelings conflict with their right. And but that's not why he's in court today. He does not have the right to assault anyone. He says he acted in self-defense, but I think there would have to be a pretty clear, more of a definition of what happened. I don't have enough facts to understand what happened there.
This first picture of the north entrance, you indicated.
Mm-hmm. Yes, ma'am.
This is the east entrance.
Yes, ma'am.
And the picture in the middle, is it basically the lobby area? A portion of the lobby area between the 2 entrances?
Yes, ma'am. It's essentially capturing it almost in a panoramic fashion, if you will, of if you were to come in through the north entrance and look to your left. That's essentially what you would see if you would pan from the left to the right.
And according to your testimony, you indicated that Mr. Farley entered on the east entrance.
Correct. Yes, ma'am.
Do you know where inside the DSH office the incident was alleged to have occurred?
It started in the long, narrow hallways that leads to the double doors that lead into the DSHS lobby. The physical altercation took place just inside of those double doors of the DSHS lobby, right next to the intake kiosk or station.
So, according to your information, the incident did not occur in the actual middle of the room lobby itself. Is that correct? It basically occurred in the doorway of the east entrance.
Objection, compound.
Overruled.
So the incident, the physical altercation itself took place by the doorways. And then when the hollering from the other patrons that were inside, that was more towards the middle of the lobby. So it did bleed into the middle of the lobby.
Did you witness this?
In your view of the DSHS lobby, the two places that you circled on the page where the notices were, they were not at, those signs were not located right inside the east entrance. Is that correct?
Correct. Well, those two that I circled are in the middle of the lobby.
And so if the alleged altercation happened in the east side doorway, had Mr. Farley seen, did he have prior notice of any recording rules?
Objection, speculation, Your Honor.
Sustained.
It is your understanding that the incident took place, I believe you said, just inside the double doorways?
Yes, ma'am.
Now, you also indicated in your testimony that you weren't concerned about Mr. Farley recording you in your interaction with him. And I believe you indicated that what is your understanding of a person's right to record?
Objection, Your Honor, speculation.
Sustained.
Is DSHS a public building?
Speculation.
To the best of my knowledge, it is a public building.
What is your understanding of speculation?
Is the lobby of DSHS a public lobby?
It does have public access.
And are there any requirements that a person has to have a set appointment in order to go to the DSHS office?
Not to my knowledge, I don't think they need to have an appointment. They could definitely walk in and, attempt to receive services from DSHS during their normal business hours.
And are you aware of any video cameras that might be located in the DSHS office?
Sure. if they have video surveillance of that building or not. I did not inquire with them at that point.
So you're not personally aware that the DSH office is under camera surveillance?
Correct. I'd have to inquire with them and find out.
Did you inquire as such that day?
No, I did not, because I was with Mr. Farley. Detective Bowling was inside speaking with the security team.
To your knowledge, did Detective Bowling
Objection.
view
Your
any?
Honor. Hearsay and speculation.
To your knowledge?
I haven't asked for any statement, Your Honor.
We'll go ahead and ask your question, then I'll rule on the objection.
To your knowledge.
To your knowledge, did Detective Bowling watch any surveillance video of the incident that happened that day?
Okay, I'm going to sustain the objection, and that's
what?
Yeah, but the objection is sustained.
I'm not feeling these rulings.
Seen any video surveillance cameras from the DSHS office?
Not that I could recollect right now. No, ma'am.
Now, you indicated that, according to Mr. Farley, he was there conducting or viewing the business practices. And I believe, according to your testimony, at some time that I believe you indicated that the security guard told Mr. Farley to stop recording. Is that correct?
Yes, ma'am.
Do you know where the security guard was located when he asked Mr. Farley to stop recording?
In the long hallway that leads to DSHS.
And you also testified that Mr. Farley indicated that he did not stop recording in the hallway and that he believed it was his right to record. Is that correct?
Yes, ma'am.
Did you at that time inform Mr. Farley that regarding any laws regarding recording?
No, I did not inform of any laws about that.
Did you discuss any particular rules regarding the DSHS office regarding recording?
No, I did not.
Was Mr. Farley arrested or cited for recording?
Not for recording. He was cited and arrested for the assault in the 4th degree.
Now we're getting to relevant issues. I think they've pretty much covered the fact that whether or not it's reprehensible, that he probably was legal in what he was doing. Might not be morally correct, but legal.
You indicate that you believe there are signs that indicate that there should be no recording, that he was not cited or arrested for that charge. Why not?
Objection, Your Honor.
Sustained.
Just objection.
Have you ever arrested someone for video recording in a public space?
No, I'm not, ma'am.
Why? You can't ask why in this court. That's one question too far.
During the investigation that followed that day, were there any patrons that contacted law enforcement requesting that any video be erased from that day?
I didn't have any patrons approach me telling me to release or erase any videos.
Any patrons that expressed any privacy concerns that they felt were violated that day?
Objection, Your Honor. Hearsay and relevant.
Sustain the objection.
Now, you indicated when you arrived, you saw Mr. Farley exiting the building. Did Mr. Farley appear to exit the building to speak with the responding officers?
I think that was by chance that he was exiting at the exact same time that we were arriving. But I do not believe that he was trying to evade or flee or get away from the situation. But he did make it a point to come and interact with us.
Did Mr. Farley share with you his opinion that he believed he was assaulted?
Objection, Your Honor. Hearsay.
Overruled.
Your Honor, ask for a sidebar, please.
Okay, jury, we're not. We're actually, we're coming up on our morning recess time. We're going to go ahead and take a morning recess right now. And
okay, so
we'll be going to break.
Interesting.
About 10 minutes.
You saw a switch on the who's making objections. The new attorney, who I guess they assigned to this case because they thought it would be a slam dunk, is running into some obstacles. The judge is making some interesting rulings. I'm almost 100% opposite of what the judge should rule. I believe that when the defense attorney is soliciting statements from a witness about the defense, they should be sustained because if they want to admit those, they can call him as a witness.
And Your Honor, Corey Thompson for the state. The court previously allowed Ms. Rowe to ask and get an answer under the party opponent exception to hearsay. However, she's trying to offer her own client's statements through the witness. That is not a party opponent. If this was a civil case and we had a client, then she could get our client's statements in, but it's her client. Right. That's not a party opponent. That's party.
This is why the defense team the plaintiff's team in Maya's case.
The admission is coming. He's the party.
Yes, but party
the law is written for them.
We are the opponent to him, so we can introduce his statements.
Right.
She cannot introduce his statements through another witness.
But
if he wants to,
hang on just a second.
He's right.
But if you begin, bringing his statements in, isn't she allowed to? I mean, you can't just pick and choose. Like, I'm just going to get this bit of his statement and that bit of his statement. If you introduce some of his statement, isn't she allowed to cross-examine him on the complete statement?
No, Your Honor. They can on anything we introduced, not the complete statement. We had we never introduced his beliefs or his opinions on things. We simply anything, the actions that the statements that were introduced of his from the state were his actions that he relayed to the witness, not about any of his opinions, about his validity or legal conclusions. She's attempting to basically get him testimony in full, his opinions about things in full, without having to put him on the stand.
Right.
And that is absolutely
Mr. Anderson could not play.
And why the admission by a party opponent only can come from one side.
Mm-hmm. He's right. 100% right.
Just a second. Ms. Rowe, and
Your Honor, I believe the state opened the door for admissions of Mr. Farley's side of the story, as Officer Navaro testified to. Officer Navaro indicated, and this was elicited out of his initial testimony, that Mr. Farley told him he was there to record business practices and daily activities, that Mr. Farley indicated that he was a freelance reporter, and that Mr. Farley indicated as I indicated before, Your Honor, I believe the state opened the door to Mr. Farley's, and Officer Navarro testified as to what was relayed to him by Mr. Farley as his version of the incident.
Your Honor, this is
not an open the door issue.
And Your Honor, that is all recitation of his actions that the state introduced, not his opinions about things. If he wants to take the stand and relay his opinions, then he can take the stand.
Who's going to speak for the state here?
The state is speaking on this one right now.
Mr. Fortunato started, but
the state's addressing this, or Corey Thompson addressing the city for the city.
Yeah, you're right. Thanks.
The new guy didn't last in court very long. He wandered in and said, "Oh, the wrong room," and then he's gone. Okay, so I believe that the attorney who's standing is in the right. And as his legal understanding, that matches my legal understanding, which is it stands for nothing. But I believe he's correct. Think of in the Maya trial, Greg Anderson was not allowed to play recordings of Jack because if they wanted his statements in, they had to bring him on the stand and testify to it. I think that's the same thing. Now, the rule about the statement by a party opponent, that rule applies just for they can bring in stuff that the hospital said, and the hospital can bring in stuff that Jack said, but
it
doesn't work where she brings in stuff.
To take advantage of having the jury out of the room to address, or excuse me, the city.
The city, yeah. Anyway, she can't bring in her own client statements that way, so we'll see. The judge, I think, was wrong on the ruling there, and he's probably consulting the big book of law and reading up on that. Why is it the city? In this situation, the charge was a crime alleged to have committed in the city, an assault in the city. So the city is the prosecuting entity on that. It's a gross misdemeanor, so it's just prosecuted on this low level. That's why we have this little makeshift court. The county does have other courtrooms. They have other courtrooms that are more proper and more formal, but this is one they set up during COVID, and they've just continued using it. The judge should know the rules. Sometimes the administrator of this court, like the judge, is like a commissioner instead of a judge. And I don't know the state law up in Washington that allows that, but I think it's think of like a magistrate versus a judge. It's just a slightly different title, but still authorized to do what they do. Judge is busy searching on YouTube for Recovery Addict channel to get educated on the finer points of the law. I think it's probably a good point to point out at this point to him that 9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom. There we go. So just be aware. Join the majority. You can watch us. I'm so tempted to skip ahead.
I'll get back to this.
Yes, Your Honor. The state does have continuing concerns that an admitted exhibit was altered after its admission. We'd ask that a new exhibit of the exact same be readmitted. We'd stipulate to its admissibility, but an exhibit that's been admitted and published to the jury has subsequently been altered, and that is problematic.
Okay, so I don't think it's problematic. I mean, I've had many trials where a lot of times people will have the easel, get something admitted, and they'll have the go up there and mark on that during the course of the trial. To me, that's no different from what's happened here. We don't do that as much anymore, given that a lot of it's digital.
Well,
to have a witness testify to an exhibit, then admit it, and then mark on the exhibit consistent with their testimony. That happens all the time, doesn't it?
No, Your Honor. I've never, in 7 years, never had an exhibit admitted and marked. Now, I have had exhibits admitted after they were marked up, off of an easel, for example. Like I have a witness draw a picture to describe something and then mark it and admit it into the record.
We're not going to do that. Okay. To me, that's really kind of a distinction without a difference. If you have an exhibit there that's may have been admitted, or it hasn't been admitted yet, then they put marks on it, then it gets admitted. I don't see a whole lot of difference between having a picture and someone marking on there. I mean, it's just, to me, that's a sequence of events, which really doesn't make much of a difference.
Well, understanding the court, the concern here is that it's now become two different exhibits. The exhibit that the jury first was published to them as they saw it for the record has now been altered in a way.
And they saw that alteration, and it was happened in real time in front of them.
But
I'm not sure what you're asking for, but I'm not going to admit a second picture of it. I mean, if the jury can see the picture, they can see the markings on it relative to where the signs were in the lobby. Allegedly, that's his position.
I understand the court's ruling. I just did want to make that for the record. The second concern the state has is if defense has any more exhibits they wish to introduce, that they be given to the state right now. We were given these exhibits for the first time and saw these photos for the first time before Ms. Rowe admitted them to the court.
Oh, we have a discovery issue.
We're not aware of any other exhibits.
Just a second. Yeah, all exhibits should be pre-marked. You know, it's a constant source of irritation to me when all of a sudden we just have to stop everything to have an attorney come in there and have the exhibits marked. Have them pre-marked before the trial starts. And if you have any more exhibits, either side, get them marked. The second thing is, you know, I asked if there was any objection to these admission, and there were none. And so that's.
I agree, Your Honor. There's the reason why the state did not object is there are photos that we would stipulate are in fact photos of the area, but we're concerned that there might be other evidence out there that has yet been discovered in violation of 4.7 obligations of defense.
Right. And if they are seeing that for the first time, had they objected because they hadn't seen it before, it might not have been admitted because they haven't been disclosed. You're supposed to disclose all this stuff prior to trial. But they didn't object. And so if you have any exhibits, you know, give them to them now, please. And have them marked.
I gave the state all of the exhibits that I plan to introduce.
Okay.
It's my understanding that the state.
Hang on just a second. He just told me that they got these pictures for the first time now. Is that right or wrong?
We got today, yes.
So the pictures that you admitted in exhibits 1, 2, and 3, those were just shown to him for the first time mid-trial?
Now we have a problem.
Yes, Your Honor.
Okay, so that's what I'm saying. That's not appropriate. You need to disclose all the exhibits well prior to trial.
Your Honor, I totally understand this trial has, and generally I do. Also, it's my understanding that the state has some exhibits that it's going to seek to introduce.
Yes, and they're already marked and they've been discovered.
And we showed them to you. That's the process.
Have I received a copy of them and a hard copy of them today?
No.
Have you been given them to you? Have you received them in the course of discovery?
She has.
Yes. I've received quite a bit of. I've received 10 videos. I'm not exactly sure which specific
Well, you can ask them.
pieces of evidence that the state is seeking to introduce today.
Right. But okay, so here's the thing.
Everyone's learning about the law
The
today.
state, if they have a mountain of evidence, they can pick and choose, or either side. If either side has a mountain of evidence, they can pick and choose what they want to admit at trial. And then if you want to ask them, they can tell you. But what's not appropriate is to have but they have to disclose it to both sides beforehand. But if you have evidence that you intend to present at trial that hasn't been disclosed prior to trial, that's the issue.
Understood, Your
And
Honor.
so, I mean, if the state, again, I don't, none of it was disclosed to me, so I'm not sure exactly what was disclosed one way or the other. But if the state or city, excuse me, picks and choose what they want to admit, they certainly can, as long as it's been disclosed to you prior to trial. It's the same thing with you. If you have a bunch of pictures you want, you can pick and choose which ones you want to admit or introduce, but you need to show those to all of them to the state beforehand. And so what I'm hearing from the city is that these pictures that were admitted, which are, we could debate, I guess, as to their value, but they'd never seen these things before. And that was the objection that they had. And that's what I think needs to be taken care of. But if the state has, you say 10 videos, they only choose to admit 2, they can, and they don't, but as long as they've disclosed them to you beforehand.
Understood, Your Honor. And this was not an intentional act. It was
oversight.
Last minute.
Which is not allowed.
Right.
And I would argue that
on this, and then yeah.
All right. I think the judge got a little spicy because he sort of got caught making a ruling that may not have been correct. And so then when he had an opportunity to chastise the parties, that's where the spiciness came out and the reason. That's my personal opinion. Okay, hold tight here. Why is this not working? Okay. Fast forward. I wish we could. This is live, unfortunately. The judge is still reading the law book. Okay, the defendant's name is Mr. Farley. We're waiting here. We've had an objection made by the city, who's the gentleman on the far right, that most notably lacking in hair on the top of his head. That's just a distinction how you can recognize him. The judge has made a couple rulings that I think may have been an error. Some rulings about what is allowed as far as questioning a witness, specifically regarding the defendant's statements by the defense. He's ruled that the door was opened and that it's a statement by a party opponent that lets these in when it's not a party opponent. Mr. Junior Lawyer, who's sitting there with the red tie, has sort of been pushed back into second chair as he made the objections somewhat weakly and at the prompting of his boss. And the judge sort of overruled him, and now the boss is sort of stepping in, even bringing the law and saying, hey, here's what's up. So we've pretty much got a mistrial in the works where we've already had one witness walk into the jury room and only stay there for a few minutes. We've had an officer directly testify to something that was ruled in a motion in limine to not be allowed in trial whatsoever, pre-trial, and that came in. We've had a motion for a mistrial, which was overruled because they determined that, the fact that something came in a motion in limine against a motion in limine doesn't rise to the level of a mistrial. And now we have the defense attorney who's questioning the first witness by the city and eliciting statements by her client from the witness, and the judge was sustaining those. And so we've had objections to that. And that's where we are at this point. Maybe the judge is new. I don't know. It sounds like maybe he's like a substitute judge or something. He just got home and tuned in. Feels like I haven't missed much. It's been interesting. It's been slower in developing, but the underlying elements are quite interesting. It's like a trial sampler. Can you imagine? Mr. Frog had all this ahead of him, and he instead skipped out of court and no-showed after lunch. And his attorney admitted she dismissed a juror in error, but it shouldn't make a big deal. It shouldn't be. It's not the end of the world for her. It might be the end of the, freedom for her client, but she's not really concerned about that. So yeah, all the things have happened in this trial already. This is a trial where the defendant on the far left of your screen, right above me, right up here, that's him there. That's Mr. Farley. He is what is termed a First Amendment auditor. He likes to go into public buildings, run into video camera, and just film. And it generally incites some sort of interaction with people in the public building, usually employees who don't like to be filmed. And he takes these encounters where he is legally, in most cases, within the law, and then he takes these encounters and he posts them on his YouTube channel, which is Pacific Northwest Transparency. He has about 91 videos up from different things, from filming just off of church properties to filming inside businesses or inside government agencies, inside the post office. He does all these things and he audits them to see if they pass the test, meaning if they allow him to film, they pass. If they don't allow him to film, they fail. And he produces these videos, which if you look at the thumbnails and you look at the content that's used in the video, it's he intends to have a reaction. The stronger the reaction, the better. He legally triggers people, says WeatherWatch. That seems to be the MO of the channel. Okay, so yes, exercising a right, but doing it in the most confrontational way possible. On film to get a reaction, which then is used to get clicks on YouTube.
Would like to address the court too, Your Honor.
Go ahead.
Your Honor, I believe also in the state's initial direct of Officer Navaro, they asked whether Detective Officer Navaro indicated that Mr. Farley told him that the security guard told him to stop recording, but that he did not stop. And then I wrote this after Detective Navaro's testimony, and it is, he believed it was his right to record. That was elicited in the state's direct, which would show that Mr. Officer Navaro did testify as to what Mr. Farley's beliefs were.
Okay, but she's using the term open.
So I'm going to overrule the objection in the sense that I'm going to allow the witness to answer and the question about what Mr. Farley had said. The state in its direct examination elicited a lot of testimony from the officer about statements that that were attributed to Mr. Farley, and it got right up next to the question Ms. Rowe asked, and just to pick and choose without giving a full characterization of the witnesses or the defendant's statements, I think it's appropriate to introduce other things rather than just, you can only introduce the things that you can't pick and choose. Once you get into his statements, I think the defense is entitled to introduce other statements.
Here's where the judge errs on this.
What the statement was, the position at the time. So that's going to be overruled, and I'm going to allow the question to be asked and answered.
Understand.
And do you have, how much longer do you intend to go here, Ms. Rowe?
I'm almost done, Your Honor.
Your Honor, I would like to point out a long history of cases that self-serving statements are not admissible.
But well, they're not. I mean, I understand that, but I think the rules change a little bit when you get into again, there's a rule on this I can't find. I'll look for it over the break. If again, a part of the statement is again, just in fairness, the other parts of the statement come in if you introduce part of it, and there's a line of cases on that also. And so
to a degree, Your Honor, this is the defendant has an opportunity to take the stand and say all of those statements, not express his opinions through another witness. That's self-serving hearsay.
I understand that. But when the state gets to start get into the statements and all of that and the admissions or what have you, then I think the defense is entitled to complete the statement. The state had not gotten into any of that stuff that was said it's for an example, if you and again, I know this was example used on me a couple more than once a time. If you have a murder case, if you have someone who says, well, I killed this person, but I did it in self-defense. State can't get on here and say, well, get the admission, well, I killed this person, and then not say, but I did it in self-defense. That is self-serving hearsay. But if you get that first part of the statement in, you're going to be allowed to supplement all of that.
Okay, but the witness's legal conclusions and legal statements aren't relevant to his actions. And they aren't contradictory to his actions or explanatory of his actions. He needs to take the stand and make that statement if the defense wishes to introduce it, Your Honor, not through another witness. Otherwise, a witness could sit there or a defendant could sit there and say whatever the heck they want to a law enforcement officer. And the instant the state tries to introduce some of their statement, defense can then introduce all of their statement. That's not the case and never has been the case.
Okay. You've created your record. I'm going to overrule the objection, and then we'll go from there. And we can.
And I only have a few more questions, Your Honor. This amount right here on my page, it's not even a whole paragraph.
Right. We'll bring the jury back in.
Okay, I think that where the judge erred is that that this wasn't an area that was prohibited. They weren't allowed to go into. This wasn't opening the door to something. Okay, this is their defense. And their theory of defense, they are allowed to bring things in, but they have to do it through the witness. The witness has to be the defendant. He is available to them. Nothing is stopping them from bringing this in. It wasn't like they opened the door. We should now have the right to get that from whoever else we want. I think if some of the lawyers on YouTube could back me up on this, maybe even Matthew. Am I right here, Matthew? If you're still here, I know you've got work and you've been with us most of the morning, but. I just don't think that that the statement was like the half sentence the judge used in the example of the admission.
Seated in the courtroom. And Ms. Rowe, you may continue.
Yes, they can. Both sides can move for mistrial.
So, Officer Navaro, going back to your testimony regarding your interaction with Mr. Farley and your communications with him, I believe you indicated that Mr. Farley informed you that the security guard got into his personal space and that he backed up. Is that correct?
Yes, ma'am.
And that there was a discussion that was had between the security guard and himself. And that this was when the altercation occurred. Is that correct?
Correct. The discussion led to the altercation.
Pardon?
The discussion led to the altercation. It evolved into that.
This comes down to hearsay and the objections to hearsay. And so there's not an objection that allows the defense to get this.
Did you at any time inform Mr. Farley that he was not allowed to video record in the public space?
No, I did
Objection,
not.
Your Honor, asked and answered.
Okay, sustained.
And I believe you indicated that there was information relayed to you that there was some chest bumping and shoving. Is that correct?
Correct.
And while you were communicating with Mr. Farley, was there any other officers around?
Yes, there was.
And were these officers also being recorded by Mr. Farley?
Yes, ma'am.
Did any of those officers request that Mr. Farley turn off his recording during the interaction between you and he?
Objection, Your Honor, relevance.
Sustained.
Seriously. Judge, would you just like to issue the ruling now? Because I think we're not getting, our strike zones are not the same between the two parties. I'm just calling it.
You subsequently ended up taking Mr. Farley's cell phone and his device that is close to a GoPro as evidence. Is that correct?
Yes, ma'am.
Did Mr. Farley resist in giving you those devices?
Objection, Your Honor, relevance.
Sustained.
You were able to retrieve the devices?
Correct.
Objection, relevance. Oh my goodness. So the devices that could have captured
And I believe the
the
last
altercation.
question that the state asked was, did Mr. Farley deny any intentional touching? And I believe your response was that he believed he did what he needed to do to protect himself. Is that correct?
That's what he had told me. Yes, ma'am.
Did you ask him to go into detail regarding that statement?
I did. However, Mr. Farley said that he did not want to answer or respond to any questions, that the statements that he had made were the statements that he was going to give and no further statements after that.
And did you personally speak to any other witnesses regarding the incident that day?
No, I did not. Not that day, ma'am.
Thank you. I don't have any other questions for you. Thank you.
Any redirect, Mr. Fortunato?
Yes, please, Your Honor. City only has 4 questions I'd like to ask, but hopefully this won't take too long. Thank you. Officer Navaro, is recording during an investigation or communications standard procedure for an officer?
Based off of Tumwater Police Department policy, it is. Yes.
Okay. Were you primarily outside when you spoke with Mr. Farley?
I rarely
The
smoke
entire time I
indoors.
spoke with him was outside.
The entire time was outside. Did Mr. Farley did tell you he was aware of the DSHS rule regarding recording? Is that correct?
Objection, Your Honor. That was not
Overruled. You can ask he asked the questions, he can answer.
I'll ask you the same question. Mr. Farley did tell you he was made aware of the DSHS rule regarding recording. Is that correct?
Correct.
To your knowledge, is Mr. Farley a lawyer?
Not to my knowledge, no.
No further questions, Your Honor.
Any redirect, Ms. Rowe? Or recross, I'm sorry.
Is he a lawyer? So how would he understand the law if he's not a lawyer?
Yes, Officer Navaro, how did Mr. Farley tell you he was aware of any rule of DSHS?
During his statement, he had told me that the security guard told him to stop recording, that there was an area that he was not supposed to be recording in.
So to clarify, he indicated to you that the security guard told him of the rule,
Correct.
not that he had any prior knowledge of this rule.
Correct.
No further questions.
Anything further, Mr. Fortunato? May
Nothing
this witness
for the
be
city.
excused?
Yes, you may.
You may step down. Feel free to leave. And Mr. Fortunato, you may call your next witness.
Go get the gentleman, the security guard. Bring him in. Here we go.
Your Honor, with the court's indulgence, the city would next like to call Mr. Samuel Kirkley.
This is not the security guard, I don't think. We'll find out, but Randy is a security guard. Ray-B, welcome to the gallery. Ray-B. Got a cute cat. I just want to see the video. Honestly, this whole thing can be solved by the video. I imagine the entire thing is captured audio and video.
Before you sit down, could you raise your right hand? You swear and affirm the information and testimony you provide will be the truth, the whole truth, and nothing but the truth? You may be seated. And Mr. Fortunato, you may inquire.
Good morning. Would you please state your name for the record?
Samuel J. Kirkley,
And could you spell that for us?
Kirkley.
Thank you. Where do you live, Mr. Kirkley?
Lacey,
How long have you lived there?
a week or two. Just moved. I used to live downtown.
And what is your occupation?
Right now, I'm getting disability or working on getting disability, and that's why I was at the DSHS office.
So I want to talk about a little bit kind of what happened before the incident. Can you walk me through what happened on the afternoon of July 20th, 2023?
I will do my best. It was another boring day at the DSHS office. I had to go in for the 6-month renewal thing, and I was just there waiting my turn. I'd been there, I think, an hour before the incident.
And I know you kind of went into this a little bit, but as much as you're comfortable sharing, what was the reason that you were at the DSHS office that day in particular?
I had the 6-month renewal. You have to do a renewal by paper, or you go in, or they stop your benefits. So I had to go in because I forgot about it. I had to do it that day because I had to be done before the end of the month. So I went in, got it done.
Go ahead.
Yeah, that's the reason I was there.
And this was for disability benefits, you'd said?
Yes,
Okay.
It's for my welfare and the disability. It's all kind of grouped together in a nice mess.
Do you remember about what time you arrived at the office?
I think it was like 10 or 11. I normally go in the morning, but I didn't realize until I got the letter in the mail. So then I went to there realizing I had to do it in a couple days.
Okay. And where is this DSHS office located?
In Tumwater off Capitol Boulevard, kind of adjacent to Israel.
Okay. Can you briefly describe to me what the layout of the DSHS office is?
What I would consider the main office, you walk in the door, and then there's a bunch of chairs. There's the check-in counter right here. Over here are some windows. You can talk to people. Over here is the door that goes into, like, I'd call it a corridor for the main building. And then, of course, there's lots of offices in the back that are kind of out of sight that you don't see when you're there.
Were you the only patron at the office that day?
No, it was pretty packed.
Okay, and by pretty packed, about how many people would you say were there?
I'd say maybe a dozen or two.
So can you tell me a little bit about what led up to that incident based on your recollection?
Well, the incident, from what I remember, kind of happened out in that corridor I described, not in the DSHS office proper, but like the corridor, because I was sitting on my phone, almost directly looking at the door that leads from the corridor. So I did not see the two people come in. I noticed because I stopped and I looked up because I heard a scuffle. And then I was sitting there and then I watched what happened kind of in amazement because it was at the frickin' DSHS office. Who comes into there to do anything other than to speak to them and then leave?
You said you heard a scuffle. Based on your understanding, did you get anything about what the topic of conversation might have been?
Yes, clearly. Do not record. The security guard was telling the assailant, you do not record in here, do not take pictures of these people.
Okay, just a second. I'm going to overrule the objection and you can continue.
Oh, sorry.
So good. If you need to re-ask your question and have him restart.
Just again, what the content of that conversation was, the topic.
The topic from the beginning to the end was the security guard telling him to not record the people in there. He does not need his phone. That was the gist, and then it led into an altercation and some physical contact.
So you said there were two individuals speaking.
Hey,
one was the security guard.
We have a witness.
Is the other individual that was speaking to the security guard?
We have two witnesses, just briefly.
I think it's him, but
would you be able to identify him with an article of clothing that he's wearing currently?
I'm not sure, to be honest.
Just what
witness can't identify
an article of clothing
what
that,
he was
that
wearing?
he's wearing currently in this courtroom.
The gray shirt.
And Your Honor, let the record reflect that the witness is pointing to Mr. Jeremiah Farley.
I think it's him. I'm not sure if I can identify him.
His name, so.
Oh my!
You said that other patrons were in the waiting area. Were they in the waiting area while this incident occurred?
Yes. Where the incident occurred, it was kind of in the corner of the check-in counter and the door that leads to the corridor, where they were here, all over
Keep
here.
this view, please.
And in the seating area proper, where you actually sit down.
Okay.
So it didn't happen
He's got a desk
in the
and
group
tissues.
of people. It was kind of isolated because it skirted. When it came into our area, they were right inside the door, and then it kind
of. Were any of these patrons speaking with DSHS personnel, to your observation?
Not in the beginning. When after the assault occurred and it kind of settled down a bit, then the gentleman was talking to DSHS, and I wasn't really listening because everybody there was getting ready to take him down because he assaulted the security officer, if my recollection is correct, 3 times. And we did not think, the whole group, the mob mentality was, this is not acceptable.
The mob mentality.
Did anyone else in the office, any of the other patrons, appear to have recording devices out?
No. We all had phones out, but nobody was recording to my knowledge because we were all looking at our phones, where the individual's phone, he was recording. And the security guard did say a couple times, if I remember correctly, I'm pretty sure, but you cannot record these people. Don't record them. You cannot record these people.
Had Mr. Farley asked you for permission to be recorded?
No.
Did Mr. Farley say anything to the security guard as they entered the waiting room area of the
Don't
office?
touch me. You can't touch my phone. I can do this. I can do what I want. Just very combative, very upset, very like, I'm going to challenge the system, but it's a DSHS office. What's the point?
Did you observe any recording devices in Mr. Farley's control at the time?
If you include his cell phone, yes, but an actual like device, like a camcorder, no. His cell phone was up and clearly looked like what was recording, not, perusing the internet or looking at cats on it.
And where was this recording device located? You said he was holding it.
He was holding his phone.
Okay.
And his phone, he was holding it out of the reach of the security guard. And the security guard said a couple times, you can't record. And then he would also say, you can't record the people. So I do remember that slight distinction.
One moment, Your Honor.
This fly's eye view is provided by the court. Thank you very much. It's better than the one we had before. If you turn your phone sideways and cross your eyes, it almost makes a single image, but it is sideways.
Based on your observations, what was the security guard's demeanor when speaking with Mr. Farley?
Calm, but a slightly elevated. He was very vocal, but he wasn't yelling. He wasn't threatening.
And kind of why would you say that? Kind of paint a little picture here. Maybe what was his facial expression at the time?
Neutral but strained. I mean, they were physically, but they weren't necessarily like fighting at that moment. It was a lot of like trying to grab the phone and just like
a dance,
like a scuffle without actually fighting.
And what was his tone of voice at the time?
A fightless scuffle.
The security guard?
The security guard.
Again, very neutral, kind of flat, very like trained, like he's doing his training. He's like, when you deal with somebody who is aggressive or whatever, you talk calmly, you talk directly, you talk firmly. Like, he wasn't yelling or screaming or being irrational, but he also wasn't being passive. He was very clear in the fact that what the assailant was doing was not okay.
And prior to the incident, immediately prior, what was Mr. Farley's demeanor based on your observations?
After the incident and the police were there.
Excuse me. I meant prior to the incident, as he was entering the waiting area.
From what I heard, my head was not up as they actually entered. So okay. I cannot say, but the conversation had started out in the corridor. And then, like I said, the security guard was close to him and telling him not to record. And like I said, they didn't walk in, they actually kind of like walked in and skirted around the perimeter.
This guy in juror number 7.
I would say Mr. Farley was defiant and I can do what I want was the impression I got. Not saying that's absolutely truth, but the security guard, kept telling him, you can't do this. And he was like, I can do what I want. It's a state building, all of this. And he was very agitated.
And why would you say he appeared to be agitated? What did you observe?
The way he was talking to the security guard, the way he was looking around, the way he was stating his rights. I can do what stuff like that. He wasn't very calm in talking to the security guard. He wasn't saying, I would like to record for a reason. He was like, I can record because I can. I have that right, was the impression I was getting.
And after receiving requests to discontinue recording, did it appear that he obliged and discontinued recording?
No, that's what led to the physical violence. The security guard was trying to grab the phone, which I'm not saying is right or wrong. Mr. Farley hit him once and then hit him again in the face. And then if I remember correctly, the scuffle ended up kind of toward the other side as it scuffled around. And I think he hit him again, and then he threatened that he can hit him. He was going to hit him again. He was screaming, yelling at the DSHS people because they came out. They were trying to talk him down. All of us in the waiting room were getting mob mentality because we're like, the security guard's just trying to do his damn job, and this guy comes in here and starts causing this big issue. And we were all just shocked. I mean, we were all there doing our thing. You know, it's the DSHS office. It sucks no matter what. And then for somebody to come in and assault a security guard just seems...
It sucks no matter what.
It just felt surreal. That's why some of the memories I have aren't exactly super clear, because that doesn't happen. You know, you're not used to sitting in the welfare office and having an assault. This isn't LA, you know, it's Olympia.
From your perspective, you said the security guard reached towards the phone?
Yes.
From your perspective, did the security guard appear to make contact with Mr. Farley's person?
Indirectly, he wasn't hitting him. He wasn't trying to grab him. He was kind of using his body to move him, but he did grab or go for the phone a few times. And Mr. Farley then stated loudly, "Don't touch my phone." And if I remember correctly, that's what initiated the physical contact, that the security guard was trying to get the phone, and Mr. Farley responded with physical violence.
And you said Mr. Farley responded with physical violence. Do you want to go into a little more detail about that?
He, as close as he and the security guard were, and the security guard was trying to grab his phone, he hit him in the face.
Was it just once?
Twice.
And was that the end of the physical contact?
No, if I remember correctly, I think there was more physical contact as it kind of escalated a bit, because, you know, everybody was getting riled up. The staff was getting riled up. The people were getting riled up. And then if I remember correctly, he went for the phone again when they were over in the other area. But like I said, it's all kind of weird because it's surreal. It's the welfare office.
How hard would you say Mr. Farley struck Mr. Rain, or the security guard in this case?
For my guesstimation, not knowing the gentleman, seeing his build and stuff, I would guess he probably hit him at 50% power. It wasn't something that knocked the guard out, but it hurt him.
Used 50% power.
How did the security guard respond to
We've set our weapons to stun, sir.
He actually stayed really calm, telling him, can't do that. Like, he didn't yell or scream. The security guard never went crazy. He never broke training or protocol, you know, which I remember was pretty impressive considering what happened.
How did Mr. Farley react after his physical contact with the security guard?
He was still very vocal. Still, I can do what I want. You tried to touch me. You tried to take my stuff. I can hit you. He got into yelling matches with other patrons at the DSHS, like yelling matches, like this one heavyset woman and him just were yelling at each other, and just the whole scene was just out of a movie. Like I said, that's it. Everything was so crazy.
You said he continued yelling. What did he say?
I can do what I want. Shut your mouth. He used, you know, derogatory terms. He was just, to me, from what I could see, he had no other business there other than to go in and cause a problem. Because it started outside the DSHS office, because they came in. So I don't know what happened out there at all. Completely will admit that. But it started out there because it ended up in the office proper. They came in. So I'm guessing they told him out there, don't record, because that's what the scuffle was as it came into the office. So, I mean,
he's got a whole idea what happened before he saw it.
Like I said, it's the DSHS office. You don't expect, you know, a brawl to occur, and you don't expect somebody to go in there and, like, after they have been violent, they still threaten the people.
After this physical altercation occurred, did Mr. Farley appear to discontinue recording?
Not really, because he eventually got a DSHS person finally talk to him and kind of calm the situation down, try to figure out, why are you here? What are you doing? I didn't hear that. I wasn't paying attention. Me and the other people were talking because we were all in awe, like, did this really happen? Like, because like I said, it's, he was agitated, he was upset, and I don't know why. Sure, the security guard was annoying him, but if somebody told me, hey, this is a DSHS office, you can't record people. Okay, no problem. Done.
And it appeared that while he was continuing to talk to the DSHS person after the incident, that he was continuing to record.
I believe so, but I don't want to say 100% sure.
Just
but
based
yes.
off your observations.
If I remember correctly, yes.
And how did you personally react to Mr. Farley striking the security guard?
It kind of triggered me because I have myself been a victim of domestic violence. That's one of the reasons why I've been saying, what I remember, because it was a bit traumatic, like I said, to have somebody come in and beat up a security guard at the welfare office. Really? Find a hobby.
Did others in the office react to the confrontation? You said that there was some
probably
others
about 4 or 5 of the DSHS office people did come out, and they started telling him, what are you doing? What's up? Why are you here? That about the same time that the personnel was talking to him, the mob mentality had already been created, and a couple people were kind of headed toward him. And then a couple people were yelling at him, like, what's your problem? Why are you here hitting somebody like this? Like,
you talk about this kind of mob mentality as a reaction to this incident of the patrons.
Oh yeah, we were like, what the hell are you doing? Why are you doing this? What's your problem? You want to hit somebody real? A couple gentlemen, burlier, taller people, vaguely like there. It was about 4 or 5 of us. I was just like, what the hell's wrong with you? Like, what is wrong with you?
So based off of that, what is your impression of the tone of the room after the incident occurred, immediately afterwards?
After the incident settled down and people were calmed down, it was, I'd say, shock, honestly. Just like I keep saying, what the hell? It's the DSHS office. Why did you come in here? And then Mr. Farley got upset, or he seemed shocked that the mob was getting ready to take care of him. And when I mean that, restrain him, not physically hurt him. You don't need to be causing any more pain to anybody.
So you went into a little bit of detail about this, but what occurred after Mr. Farley struck the security guard?
That's after the physical violence. That's what turned everything up. As soon as because we were all kind of looking at the scuffle, but as soon as he got hit, when Mr. Farley hit the security guard, that is when the mob mentality almost instantly started, and people were saying what the hell's wrong with you? You need to stop. And then that's when DSHS, the personnel, started kind of coming out, and they were even shocked and kind of staying back a little bit, I think, for their own safety.
So I think you might have gone into a little bit of detail on this, but did anyone provide aid to the security guard at that point or intervene?
I believe a DSHS person came out and kind of was a buffer, and talked him down, or 2 DSHS people.
And excuse me, this is to the security guards.
Yeah. Okay. The 2 DSHS people that came out were talking to him, trying to figure out what he's doing, why he's doing it, getting him calmed down. They were trying to de-escalate the situation. They were trying, then others were trying to calm down the mob mentality, because we were like, hey, what's wrong? And then there was 4 or 5 of us who specifically went to the police officer and said, hey, we would like to, give you our recollection, our information, because we all agreed, this was unacceptable. This isn't the Wild West.
Did anyone provide aid to Mr. Farley?
No, but we were getting ready to. After the first hit, that's, like I said, that's what riled up the crowd. Everybody there just trying to wait and get their time to speak with the DSHS people. Once he did, people started actually getting out of their chairs and walking toward him. I remember a taller gentleman over on the left, because I was sitting here looking this way. He started to yell at him and telling him, what type of man are you that you come in and beat up I'm sorry, the security guard's a nice guy, but he's not very big. You could push him over with a hard breeze. And that's kind of what went on power. A lot back and forth was the what's wrong with you, and the crowd was to a point unnecessarily riled up. Like they were still kind of like making comments about him and masculinity and all of that. Because again, I think everybody afterward with the staff and the people in the office were shocked. Like I said, it wasn't just a scuffle or even a, hey, you can't have your phone and then, whatever. And then, that it escalated into physical violence where it doesn't seem like it needed to. In my opinion, I don't think the security guard should have grabbed the phone, but he shouldn't have had his phone. Had he not had his phone, like he asked, none of this would have happened. If somebody would have said, we can't have you recording these people, because I do remember the security guard said people, not just the office, but you can't record these people. And that's when because as soon as they came in, that's when it seemed to escalate, because the security guard was trying to get his phone from him, and reaching for the phone is what the guy hit him.
And that at that time, when that conversation was happening, there were people present in the office.
Oh, yeah. And we were all, like I said, most of us were on our phones. We were on our phones, and then almost all of us, you could tell, heard something, and we all kind of looked up collectively, like, what's going on? And then we were kind of there sitting there, I think, watching it in amazement. And then when Mr. Farley struck the security guard, that's when I stood up, other people stood up. Like, what are you doing? What's wrong with you? DSHS staff was notified. They came out. I believe so. Another gentleman came out from the corridor area. I don't know how else to say it. It was just insane. It's a welfare office. I can't get over the fact it's a welfare office. We go in, we do our thing, we leave. There should be no physical violence. There's no reason to record people in the welfare office. This whole thing didn't have to happen, is how I see it at all.
And based off your perception of what happened immediately following the incident, you call it this mob mentality. None of the patrons that were there visiting went up to Mr. Farley to console him or to
be on his side.
I guess for lack of a better term, yes.
No. I was shocked that the DSHS people were actually talking to him. There was 4 of us yelling that call the cops. This dude needs to take his ass to jail. He assaulted a person in DSHS office for no reason. Was all of our attitude. We were all pissed because it slowed down being in the DSHS office even longer. So we were there, an extra probably 45 minutes because, the staff had to stop and deal with this incident that never should have been an incident to begin with.
That's why they were mad.
Thank you for your time. Longer. City has no further questions.
Ms. Rowe, you may cross-examine.
Thank you, Your Honor.
Oh, please bring the heat, Ms. Rowe. Please bring the heat. This is ripe. Oh, can you imagine Nick stepping up right here? Nick Whitney.
Kirkley.
Yes.
You indicated that, at the initial questioning by the city of Tumwater, excuse me, they asked you to describe the layout of the office. Have you personally seen any notices regarding any recording?
No. That was brought up and asked, and as I said to the police officer then, I'll say it now, no, there was no signs that I saw in the main office. There may have been one in the corridor, but I do not know, so I can say no, I did not see one. Am I allowed to follow up with that statement?
You can ask the question. You answer them, and then if they have follow-up questions, they can ask them.
Okay.
He wants to be so verbose. Oh, this is good.
And you indicated also that the incident happened in the corridor before both the security guard and Mr. Farley were even inside the office. Is that correct?
Yes, but I do not know what happened in that corridor. All I know is that the reason I say that I do know what happened in the corridor is because they were talking and yelling and next to each other in an uncomfortable position as they were coming in the door.
Describe what you mean by next to each other in an uncomfortable position.
The security guard was trying to stop him from coming in. That's why they skirted around the perimeter, as I was describing earlier, is because the security guard, as I said, from what little training I've had, was doing what he was trained. He was trying to keep Mr. Farley from everybody else. He was trying to block him from recording.
Look at the prosecutors.
And that's why I say I don't know what happened in the corridor, but something did, because it's proceeded into the office proper where we were.
Understood. Understood. Do you personally know whether this security guard had the right to try to confiscate Mr. Farley's phone?
No, I do not.
Objection, Your Honor. Calls for conclusion. A legal conclusion.
Your Honor, I would argue that this witness
the question's been answered negatively, and so well, you could just move on and ask.
Strike that objection, Your Honor.
Did you, during the incident, see or witness any DSHS employee coming over to Mr. Farley and advising him that he was not allowed to record?
I do not remember them saying that, but when the DSHS people were talking to Mr. Farley after the physical altercation, I wasn't really paying attention to what they were saying.
Okay, I wanted to know whether you heard, as well as the other patrons in the lobby, may have heard any DSHS employee advise Mr. Farley that he was not to record.
No, but I wasn't paying attention at that time either.
Understood.
If they played the video, it should match this guy's story like second for second. It should be identical.
And you indicated that everybody in the lobby, well, most folks in the lobby, to your understanding, were all on their phones.
Yeah, most of the people that were single or, they're by themselves,
they were on
Tinder. Their phones, like myself, or some of them had kids. So most of us were preoccupied. We weren't staring at the corridor door. Santa Claus could have walked in and we wouldn't have noticed till we lifted our heads up.
Understood. Did you notice anyone
Santa Claus
begin to record when the incident and the altercation happened?
Like other people?
Yes.
I did not see that.
Are you aware that there might be cameras in public spaces such as that?
I would assume there should or would be cameras all over it, being a DSHS office, a state building.
And what would those cameras be doing? Would they be recording?
My assumption.
Sustained.
That was an objection for relevance. You got to make these objections. Santa's not going to come walking into any of these people's rooms.
Have any knowledge as to whether Mr. Farley actually had business there? Yes or no?
No.
That's it. I'm enrolling in law school.
During the
LSAT,
melee, as you seem to testify to, did any of the patrons in the office object to being recorded?
A few people were upset once they realized that's what the security guard was doing to
Did
prevent the
anyone
recording.
express a objection
Yes.
to being recorded?
Yes.
And who was that?
Other people, I did not get their names. We did not discuss it extensively, but like the heavier set woman, I remember she was a very large woman and she was yelling and screaming at Mr. Farley and he was yelling and screaming back.
So what the yelling and screaming, was it a yelling and screaming because you've invaded my privacy? Or
You're
was it
recording
hold on,
and
if you
showing
wouldn't
it.
mind.
Sorry.
Okay, hang on just a minute. Let her finish her
Sorry.
question, and then when she's finished her question, you can answer. And because when two people are talking, no one can understand either one of them.
Sorry.
So Ms. Rowe, you can repeat your question, and then Mr. Kirkley, you can answer.
Was the yelling and screaming, I believe it was your testimony that the yelling and screaming was regarding what patrons believed to be a physical altercation between the two. Is that correct?
Yes.
I'm hoping this takes till tomorrow
And
morning.
I believe you indicated that things that you overheard as the incident was coming from the hallway into the actual office itself was the security guard was saying you cannot record these people and without asking their permission. Is that correct?
You cannot record these people and you cannot record. He may have said permission, but I don't remember it. But I do remember him stating you cannot record these people. Like that was the main gist.
I understand.
Yeah.
Were you privy to the recording that was being taken in real time?
No.
Were you privy to any screenshots that showed Mr. Farley recording any individuals? Did you see any recording that shows that Mr. Farley was recording people or these people?
Objection, Your Honor, relevant.
I'm going to sustain the objection, and then you can ask your next question.
Now, you indicated that during the incident, you heard Mr. Farley saying over and over, "Don't touch me, don't touch my phone."
Yes.
Is that correct?
Yep.
And I believe you indicated that he was holding his cell phone, and that's what it appeared to be was a recording, correct?
Well, very obviously, yes, because I'll use my phone he was like doing this. He wasn't doing this. He wasn't even doing this. It was this. And when the security guard was trying to grab it, he had it up here. So yes, I can say
Understood. Yeah. Absolutely understood.
Yeah, we get the picture now.
And I believe
Thank you
it
for
was your
showing us.
testimony that Mr. Farley was holding his phone out of the reach of the security guard.
Yes.
And the security guard was going towards him, trying to grab his phone.
Yes.
I believe you also testified that the security guard was in very close proximity to Mr. Farley in order to try to ascertain or to confiscate the phone. Is that correct?
And contain him, yes.
Pardon?
And contain him. He was trying to keep him away from us. That was what we all got the impression was the security guard was trying to keep him from recording us and kind of keep it separated. That's why they didn't just casually walk into the office talking like normal people in a welfare office talk.
Understood. And because of the tenure of the incident as it was going on, is it safe to assume that the security guard, in fact, I believe, was basically invading Mr. Farley's personal bubble? Yes or no?
Yes.
So we have bubble invasion that's taken place.
But isn't that his job? Okay, just sorry. Answer.
But isn't that his job? Oh, man.
And I believe it was your testimony that in fact, I believe it was your characterization or your testimony that you didn't really know if the security guard should have been trying to get grabbed for his phone or not.
Exactly. I still agree with that.
Thank you.
Kip's looking over at the prosecution table, and they're not making eye contact with him. They're sort of just leaving him out on his own.
And I believe you also testified that Mr. Farley seemed agitated and was stating his rights. Is that correct?
I would say yelling and screaming them more than stating them.
My only concerns with this witness is that he says mob mentality and we all got together and went to tell the cops that this is what happened, and that sounds a little fishy.
And did you witness the security guard make contact with Mr. Farley?
His body? Never.
Did the security guard make contact with Mr. Farley's?
Object, Your Honor. Asked and answered.
I'm going to overrule objection for now until I hear the entire question. Ms. Rowe?
The security guard was reaching to grab Mr. Farley's phone?
Yes, the whole time.
And Mr. Farley's phone was in his hand?
Yes.
And the security guard and Mr. Farley were in close proximity to each other?
Yes.
Now, you described the altercation that you witnessed. Did Mr. Farley, did you see Mr. Farley clench his hand in a fist?
If I remember correctly, yeah, he was very agitated. He wasn't in there calmly. He was vocal, yelling.
Did you see him clench
his fist?
His fist.
When he hit the dude, yeah.
What arm did he use?
I believe it was his right arm. But again,
so what arm was the camera in?
His left and the right. It was being switched between because the card was going after it.
I think they're going to start having problems once they start playing video. Problems with this testimony. The next question is...
And I believe your testimony was the security guard went for Mr. Farley's phone once and twice, and then actually went for the phone the third time. Is that correct?
Yeah, it was something like that. Very vocal, not a random trying to just grab the phone, telling him you do not need to record in here. You cannot record in here. Going for the phone, not just going for the phone unexpectedly out of the blue.
This trial is live. The event happened in July.
Do you have any personal knowledge whether or not a security guard's duty is to confiscate other person's personal property? Yes or no?
Objection, Your Honor. Speculation.
What you witnessed was the security guard going for Mr. Farley's personal property. Is that correct?
Yes.
I'll say this again. I'm not a big fan of what the defendant does on YouTube. I don't like the style of what they do. But I will say that I think that he has a right to
And I
do
believe
much
your
of what he
testimony
does,
was
even
that
though it's
throughout the
offensive.
incident, the security guard stayed calm. Correct?
Calm-ish. I mean, he was dealing with somebody who was trying to he was as calm as I think anybody could be. He was way calmer than I would have been at that point.
Understood. Thank you. And I believe you testified that from your opinion, the security guard never broke training protocol. What do you mean by that?
He was calm. He didn't yell or scream at the dude. He was loud but vocal, not yelling. He was very clear, telling the assailant what he needs to do is you cannot record these people in here.
But you don't know if his training protocol allows him to confiscate personal property. Yes
I
or
have no idea what their training protocol is.
Thank you.
But he didn't break protocol. Now, next question. Is 50% power more than a stiff breeze?
And I believe you indicated that you heard Mr. Farley basically yelling regarding being touched by the security guard and don't take my stuff.
You do it again, I'll hit you again. I can do that.
Did you hear him say, stop touching him and he can't take his stuff?
Not exactly as you stated it, no.
How did he state?
Don't touch my stuff, back off. I can do what I want. You have no rights. I can come in and be an asshole to everybody.
He said, I can come in and be an asshole to everybody?
No, but that was what we all assumed.
But that's not the words you heard.
No.
Not in those words. What did he say? He said this. In those words? No, not in those words. Oh my goodness. This is great.
And I believe that you indicated that it was your impression that Mr. Farley had no other business there but to cause problems. Is that correct?
Exactly.
Yes or no?
Okay, so hang on just a second. So ask your question again. I thought there was an objection.
There was, Your Honor.
Okay, so please restate your question just for the purpose of the record. Because again,
I believe you testified that it is your impression that Mr. Farley, and I believe I would quote, had no other business there but to cause problems. Is that correct?
Okay, don't answer that question. Is there an objection to that question?
There is, Your Honor.
Okay.
And the basis is that this is asked and answered. Many of these questions have already been answered that have repeatedly been asked by Ms. Rowe.
And I'm going to sustain the objection, partly based on your question. I think you asked if that was his testimony. And so he had already testified to that. So it is asked and answered. So I'll sustain the objection.
Somebody need a Snickers?
And I believe you testified that you believed that employees of DSHS came out. Is that correct?
Your
There
Honor.
were other employees from DSHS, that were trying to de-escalate the situation?
Objection, Your Honor. Same basis.
I'll overrule this objection. You can answer that question. If you remember it, I can have her repeat it if you wish.
Yeah, no, DSHS personnel did come out. 2 of them came out, and then more people came out from the offices, but they were behind the check-in area because he never checked in. So why was he there if he didn't hit the button like you're supposed to? You get a thing. You go to the desk. He never did that. Everybody who goes
Is
to
there?
Everybody hits the button.
Is
He
there-
didn't hit the button. Why was he there?
Our people, did it appear that Mr. Farley was coming into the DSHS office?
Well, it didn't appear to come into the office. He was there.
And as part of the administrative personnel that came out to de-escalate the situation, did any of that personnel inform Mr. Farley that he could not record?
Objection, Your Honor. The witness has already said to Ms. Rowe that he did not hear any of the conversations that were had between the agent and Mr. Farley.
Sustain that one.
Yeah, I'll overrule. You can answer the question.
Seriously? I don't remember. I'm sure it was discussed because that's the whole reason the incident occurred.
But you don't remember hearing that?
No.
Okay. Is it true, Mr. Witness, that you're only mad because
conversation
DHS came and talked to him before you?
The administrative personnel had with Mr. Farley, was he continuing to record that communication? Yes or no?
No.
Did he appear to be recording during the conversation with the administrator?
I was not paying attention very much to them. I was talking to the other patrons in
Understood.
there.
Thank you. And you indicated also that there were patrons that then went to law enforcement to give statements. Is that correct?
Objection, Your Honor. Same basis. This is a question that's already been answered.
Oh, you can answer.
Yes, there was myself and 2 or 3 other people. The security guard and then a couple other people offered to give testimony. There was one person, the police officer came in and she gave him his name and number. And then I eventually was taken out of the office and then taken into a separate area to give my testimony or talk to the police officer.
Okay.
And he said there was other people who had given testimony, but he didn't go into names or anything with me personally.
Thank you.
This is amazing.
And I believe
I think we have one more witness.
You testified as an answer to one of the state's questions that you don't think the security guard should have tried to get his phone. Why did you think that?
I do not think the security guard should have tried to grab his phone. I think he should have tried to get him out of the building, which I think he was trying. I believe he should have called for help sooner rather than later.
You believe who should have called for help?
The security guard to take care of Mr. Farley, to get him out of the office or get him arrested.
Why would he need?
After you physically assault somebody, you get arrested. Sorry.
Go ahead, Ms. Bro. You can ask your next question.
I didn't hear what they whispered.
Would you characterize someone trying to confiscate another person's property as an aggressive action?
Objection, Your Honor.
Sustained.
Just ask this witness another question to get him free spooling. Because the more he talks, the harder it's going to be to match up his version of the events with the video. That's it. Elizabeth, this is your hometown. It's why aren't you down in the courtroom right now in the background, observing everything for us? Wish we could see the judge too.
Thank you, Mr. Kirkley. I don't think I have any other questions for you.
Any redirect, Mr. Fortunato?
Nothing from the city, Your Honor.
Okay, may this witness be excused?
Yes, he may.
Mr. Kirkley, you're free to step down. Thank you, sir. You're welcome.
Do we have any more witnesses from the city?
Members of the jury, normally we take a lunch break, and we're going to do that now. It's a little normally noon to 1:30, but since it's a little bit early, we'll start our lunch break a little bit early, and then we'll come back a little bit early now. So now it looks like it's about a 10 to 12. So we'll reconvene at 1:15, continue with testimony with 1:15. I still believe we can get this trial will conclude today based on what's happened thus far. And so the instruction that I gave at the close of business yesterday, near the close of business yesterday, remains in place. Don't talk about this case. You can have conversations with friends or family members over the lunch hour, but don't discuss what you've heard. People sometimes, jurors, they eat lunch with each other, which you're entitled to do that. Do not discuss this case. Do not begin any sort of, because if you start discussing the case, then you start deliberating. Don't talk about the case until anything you've heard thus far, and until you're back, until deliberations start. So that's it for today. You could be back in the jury room by 1:10. We'll restart at 1:15. And I'll ask counsel to remain in session.
Okay, so I'm going to give the judge a 3 out of 10 on those parting instructions to the jury. He got the main elements in, but they were not quite the smooth recitation that we've come to know and love. Yes, let's see. Thank you, Tony, for that I struggle with math and time. So 4:15, Greeners.
So
thank you.
A couple things. Well, you can be seated while we're still on the record.
Yes, please.
I found what I was looking for finally with regard. I want to go back to the self-serving hearsay discussion that was had earlier. And then what I was looking for was evidence rule 106, which indicates when a writing, a recorded statement, or any part thereof is introduced by a party, an adverse party may require the party at that time to introduce any other part or any other writing or recorded statement which ought in fairness be considered contemporaneously with it. That, while this wasn't a recorded statement or a writing, that was expanded in State versus West, 70 Washington 2nd, 751. I'll quote directly from that case, which is from Teglin's book on evidence, where one party has introduced a part of a conversation, the opposing party is entitled to introduce the balance thereof in order to explain, modify, or rebut the evidence already introduced insofar as it relates to the same subject matter and is relevant to the issue involved. This is true, though the evidence might have been inadmissible in the first place. And then that's the quote from the case. And then Teglin writes in the courtroom handbook on evidence, when applicable, the rule of completeness overrides the hearsay rule. My recollection and my notes tell me that when the officer Navaro was testifying, he did testify about conversations he had with Mr. Farley, which included when things got physical and the double doors, it became physical and between Mr. Farley and Mr. Rainey. And so my ruling is that when that conversation is had, Ms. Rowe is entitled to expand on that about additional misstatements that Mr. Farley had made, which in a vacuum would have been self-serving hearsay and would not have been admissible, save for the direct testimony elicited by the state. And so I just wanted to clarify my ruling on that issue. And I understand you're going to disagree with that, which is totally fine.
It's good.
But that's what I did. And I just want to give further background for that. But go ahead, Mr. Thompson.
Thank you. I just want to make sure I understand that the specifics here is that the court is ruling that the hearsay statements that the defendant made regarding his opinions on legal matters were relevant to the actions during the course of the assault.
Well, the question the testimony that I recall was that he was either assaulted by Mr. Rainey or he did what he had to do to protect himself. That was the test. That was the part of the conversation that was admitted. And so if you want to characterize and I'm finding that is self-serving hearsay, and it became admissible when the discussion about the physical contact in the first place was had under state's direct examination.
I do believe that his statement that I felt it necessary to protect my property, if he made such a statement, and I don't recall him making one, but for argument's sake, I'll stipulate that.
I recall that was what Ms. Rowe said. Anyway, go ahead.
The bigger concern was the legal conclusions that the defendant tried to relay to various witnesses about his right to do X, Y, and Z. And it goes to a bigger concern the state has here is that defense intends to, at this point, argue a right to protect his First Amendment ability to record wherever he wants. And that is factually and legally inaccurate.
Right.
And I think and the state at this time is making a motion to preclude such argument in closing.
Okay. Well, we can certainly get to that. I mean, which I guess gets to my, well, anyway, that's my ruling with regard to the self-serving hearsay objection earlier. With regard to, and I haven't seen any jury instructions in that regard from Ms. Rowe, is there, which is, I wanted to talk about that before we broke for lunch also in terms of jury instructions, because I would like my strongest desire to get this trial done today. And so I would, there's one more witness, correct?
One more.
And then if Mr. Farley decides to testify or not, and then I want to go straight to instructions and argument. And so I want to get those taken care of. So you reviewed you proposed a knowing instruction?
No, the knowing about recording?
Yeah.
No, the state produced that and I was going to object.
Wait a minute.
The state proposed that.
Let me just
Your Honor, let me explain. The jury instructions that I proposed was simply one extra instruction. I believe it was WIPIC 1004.
Right, which is the knowing instruction. That's what I'm talking about.
It might not be that one.
A person who acts knowingly or with knowledge with respect to a fact when he or she is aware of the fact, it is not necessary for the person to know that the fact is defined by law.
Okay, not that one.
That's the one you proposed.
That's not the jury instruction that I'm talking about. Let me see which one it is.
The only instructions I got from you was that one?
Yes, those were
Actually,
those
that
I
one
am
twice,
still proposing.
cited and uncited.
Pardon?
So yeah, so
yes, I'm proposing that. Yes, Your Honor.
Okay. And then is there another instruction that's the only one I see that's been proposed by the defense?
Yes, that's correct.
Okay.
But if we are talking about the jury instructions from both sides that have been presented, there is one that I object to that the state is proposing to present. And that is, I don't have the number. Let me see. 1, 2, 3, 4, 5, 6. Instruction number 6 is regarding recordings. And I do have an objection to that instruction. And the basis for that objection is that Mr. Farley has not been charged with a crime of recording unlawfully. Because he has not been charged with it, I think this instruction can be confusing to the jury, and I would be objecting to it as irrelevant to the issue of assault. We are not here to decide whether Mr. Farley violated any criminal laws by attempting to record. It has not been established what he was attempting to record, if anything, when he was actually inside. But because the charge is not related, of assault is not related to the recording, I believe that instruction would be confusing to the jury. I don't believe it's relevant. And
Mr. Thompson.
Thank you, Your Honor. It is incredibly shocking to the city that Ms. Rowe would argue that it's not relevant when she has spent nearly all of her time with every witness pointing out the recording issue, or at least an issue with recording, and has on more than one occasion elicited from more than one witness that the defendant has stated that it is his right to record wherever he wants. In fact, she went so far as to highlight it with the most recent witness that he made the statement. In fact, I think she asked him 3 different ways if he made some to get to essentially that statement that Mr. Farley believes he has a right to record wherever he wants, whenever he wants, essentially. I'm obviously paraphrasing here. The fact of the matter is he is not currently charged with a crime involving recording. It's true. However, again, Ms. Rowe has spent a considerable amount of time pointing out this recording as being a issue for the trial. I think it's important for the court, or excuse me, for the jury to understand that the law says about recording individuals' private conversations.
I would like to
more than one witness, or excuse me, the witness, and I'm forgetting his name, Mr. Kirkley. Mr. Kirkley.
There were so many.
Did indicate that the witness or the security guard said you can't record people, and he even put forth that because it's people's privacy information, it's private information, it's a welfare office, they're getting disability benefits. This goes directly to the issue that Ms. Rowe has raised through the course of the trial, which is her client's ability to record and protect that recording.
And I'd like to respond, Your Honor.
I don't understand how it could be confusing to the jury, as it helps them understand and explain what the law actually is, as opposed to allowing either counsel or myself, or excuse me, Mr. Fortunato, to stand up at the end of this and make wild statements and accusations that are not legally or factually accurate.
If I could
Ms. Rowe, go ahead.
Your Honor, I disagree with the state's position that the recording issue was brought out by myself. This is actually the state's case and its own case. It highlighted the fact over and over through testimony, not only through Mr. Detective Navaro, but through testimony of the witness, Mr. Kirkley. They were the ones who laid out the case of Mr. Farley being there to record. I would also argue that it is the city's duty to charge what they perceived as violations of a criminal, violations of the law. I believe that it is very telling that the city did not also charge Mr. Farley with breaking any criminal laws regarding his ability to record in public spaces. And I believe that this instruction would give the jury the impression that Mr. Farley somehow broke the law. I would argue that Mr. Farley did not have the opportunity to make a choice. I would also argue that Detective Navaro himself testified that it is not illegal to record in public spaces, and to include this jury instruction would be irrelevant to the issue of assault. Now, had the state charged Mr. Farley with 2 counts, one of violating RCW 9.73.030, which is attached to that jury instruction, I would not be making this objection. This is an assault case based on a perceived and truly, honestly, Your Honor, it is not going to be established in this trial that Mr. Farley broke RCW 9.73.030. It's the reason why Detective Navaro, I've made my argument, Your Honor.
Your Honor.
I think this instruction would be highly prejudicial to Mr. Farley in the determination of whether or not an assault occurred.
Well, do you agree then that I think the city's point is that, and I think their concern is that the defense is going to be Well, he was just protecting his constitutional rights.
Your Honor, I do not plan to make any arguments or elicit testimony as to constitutional rights. As this court is well aware.
Or right to record.
Or right to record.
There were several incidences
If
where
I could-
Mr.
If I could finish.
Please. Go ahead.
This defense is not intending to even open the door to go down the path of what a layperson perceives are his constitutional rights. I believe that it's pretty obvious. So I do not plan to go down that rabbit hole.
And
as a result,
just from watching the trial, it seems like you spent a fair amount of time in that rabbit hole with these witnesses.
It seems what?
It seems like you spent an awful lot of time in that rabbit hole with these witnesses, asking them about, right to record and so forth. And so I guess, that's the city's concern. And my curiosity is that if you're not going down why would you be spending all that time on that subject with these witnesses?
I didn't spend very much time on asking whether or not Mr. Farley believed it was his right. I didn't spend very much time on that at all, Your Honor. I'm not remembering. I might need to review my notes. But
I recall a lot of testimony about signage and maybe I'm misremembering about signage and posting and whether he was allowed to do that and whether it was legal for a person to record in public buildings and whether someone knew about that. And so I think the concern of the state is that that's going to be the defense. And you don't have to tell me what your defense is. And I think that the reason the state's proposing this instruction is just to undercut that defense, which is understandable. So anyway, I'm going to hear.
I'll be very brief, Your Honor.
Mr. Fortunato wanted to say something, but you're standing. So
Your Honor, I cede to Mr. Thompson.
Well, I'll just be very brief. Is the state's concern is if we don't give that instruction proactively with the rest of the jury instructions, if Ms. Rowe then turns around and does in fact make such an argument in closing, and the court feels it necessary to clarify a legal issue that is inaccurately stated in closing, that we have to give this instruction on the backside, draws more attention to it. Again, Ms. Rowe specifically asked a question with the last witness that was, or maybe it was the first witness, is it legal to record? And we have a law that says it's not, and it's irrelevant whether or not he's been charged with it. And at this point, the state would ask to amend the information. We spent a lot of time talking about it. Well, if Ms. Rose says he hasn't been charged with it, we haven't rested our case. With the court's permission, we can amend. The evidence has been known to Ms. Rose from day one. There very clearly is a statute here that has been violated, at least from the evidence that's been submitted thus far. And we would ask to amend and add a count 2, and we'll do a written information or complaint during the lunch hour.
Whoa. Did you hear that?
Your Honor, I think it would be highly improper for the state to seek to amend the complaint in the middle of trial. I also
They're adding charges for filming in public.
Bring the court's focus to the instruction. There has been no testimony that any private conversations were recorded by Mr. Farley.
That's incorrect.
There has been...
One at a time. Go ahead.
There has also been no testimony regarding, in fact, the court sustained the objection when I asked a question regarding any consent given by any parties. The state objected to that line of questioning, and the court sustained that objection. It's my belief that the court sustained that objection because the things that are alleged to, that the issue of this trial is whether or not an assault occurred. The issue is not whether or not Mr. Farley violated a law. This issue of this case is an assault. The testimony that I elicited during my cross-examination was to ask Detective Navaro to point out the locations of notice
I'm listening.
that
Judge
does
is like,
not
don't stop now.
pertain to this instruction. And as I said, I truly believe that this instruction would convolute and confuse the jury from focusing on what the issue of the trial is, and that is whether an assault occurred. And if the state is going to be allowed to introduce this instruction, then I would like the opportunity to be able to recall Officer Navaro and recall the witness, Mr.
Nobody can remember his name.
Kirkley, as to their understanding of what this law is.
They're not attorneys, Your Honor, and
No, they're not. They're fact witnesses.
and additionally, she had notice of the proposed instruction when they were prior to them taking the stand. They've both been released from their subpoenas. And I think it's very telling that Ms. Rowe just highlighted that she asked a witness about the signage regarding recording in the same argument that she's saying it's not relevant or she's never made it relevant. She absolutely did when she had a witness circle an exhibit of where the signs regarding recording were located.
And I'd like to explain to the court why that question was asked. And that question was asked in regards to whether or not my client had notice of what the security guard was telling him. He had no notice. And I believe that it was very telling in the pictures that were presented to both the witnesses and the jury that both of the signs that indicate, that show the rule inside the office were not located in an area that Mr. Farley even had notice of. This case might have gone differently were there such notice that Mr. Farley had beforehand. The notice that appears to be posted at the DSHS office is located in an area where Mr. Farley had not even been able to get to. So my line of questioning regarding where the notices were posted was for that reason, because I do plan to argue in closing that there was no posted notice to Mr. Farley. He was simply required to rely on a position that the security guard represented to him. He didn't have any public notice.
That's not.
But the whole point of the reason why I was asking him was to establish notice.
Just stop for a minute. Okay. That's not the point. And that's not an appropriate defense. If he's saying that, okay, so he's being told to stop recording, he thinks he can, so he can hit a guy. I mean, that's not a defense to an assault. If he's being, let me finish, please. I've heard a lot of talking, so just let me finish. If he feels like he's being advised inaccurately, he withdraws and he can bring a civil suit of some kind. You can't hit someone just because you're getting bad information. And I'm not even sure the information's bad, but just because a security guard says, hey, you can't do this here, and which he really can't. But even if he could, the answer is not to hit someone.
Your Honor, what I expect to elicit from the state's third witness, and that is the security guard himself, is that he was acting without lawful authority in his attempt to confiscate Mr. Farley's personal property. And that is the position of the defense, is that it was the security officer that did the first intentional touching that created this incident. It was the security guard's actions of getting into Mr. Farley's face. It was the security guard's actions of lunging at Mr. Farley at his person 3 times in an attempt to retrieve personal data. He didn't ask Mr. Farley to hand over the cell phone. He didn't ask Mr. Farley to turn off the cell phone.
We haven't heard that. Here's what's going to happen for now. First of all, I'm not going to allow the state to amend the complaint, given that part of the reason is the testimony. The cross-examination would have been, I'm certain, quite a lot different. There wasn't a question about consent. The state objected to, and then I sustained the objection. Consent's a part of that thing, so I'm not going to let the state amend the complaint. With regard to the proposed instruction, I'm going to look at that. I'm going to do some research. I'm going to look at that over the noon hour. I'll have a decision on that when we come back.
Yeah, I mean,
and so
the state would object to any self-defense claim by defense or
yeah,
defense of property. There's zero notice.
Again, that instruction hasn't been proposed, and if it is proposed, we'll deal with it then.
Thank you.
And I'll deal whether the evidence supports a self-defense instruction or not. And Ms. Rowe, if a self-defense instruction is not given, you're not going to be allowed to argue that.
I absolutely understood, Your Honor. But there may.
Okay, I just leave it at that.
Okay.
And give me some time over there and I'll figure out what we're doing. Until then, any objection to the state, to the knowing instruction?
I don't understand its basis or reason for being.
I don't either. Why are you proposing that instruction?
Your Honor, I would have to look at it and I could.
Well, I want to print these jury instructions off over the noon hour. And what's going to happen and then the state proposed where he doesn't have to testify, and if he doesn't, it won't be held against him. I always print that up. If he chooses to testify, I just pull that instruction out. So it just goes like instruction 4 to instruction 6 without explanation.
Yeah, and then we would ask the court that, yes.
So that's why I don't want to take time to print the instructions later. So I guess if there should be an intentional instruction in there someplace, I think there is.
I'm sorry, Your Honor, what was that last statement?
Hang on just a second.
So the state is, or the city is not going to be able to.
So, Your Honor, in reviewing the proposed jury instruction, as this court knows, we basically were preparing for trial over the weekend. When I'm looking at this now, I had this in my pile of jury instructions for assault. At this time, I will withdraw this proposed instruction. I don't see a reason why it needs to be included in this particular case. So that's no problem.
It won't be.
And Your Honor, the state does have an intent or intentional.
Yeah, I saw that.
Juror instruction.
So anyway, that's it.
Thank you.
Okay, no, we're a little bit.
And with that, they cut off the Zoom feed, and we get to go to lunch. We have less than an hour. They'll be back in less than an hour. So this is our second lunch. It's like second breakfast, but it's our second lunch, and we're going to get a little bit of a break again, and then come back with a little bit more. Okay. I have a couple things. First of all, before the phone rings, I'm supposed to play this. And this is for Ayden. Is Ayden here? Let's see. That was for Ayden's dad. Russian happy birthday. Happy birthday, Papa Victor, I think we're saying. So there we go. Let's see. Now we get a call. We have a local. We have a local up there. on the ground in Tumwater, who has the behind-the-scenes scoop and knowledge about not just this case, but the other really fun one that's going on.
From attacking nurses.
Wow, holy cow. 26 corrupt cops ending their careers, apparently. That was the next video to play on that YouTube channel. Wow. Okay. We'll skip that for right now. Where are we at? We're going back to Thurston County. District 4 page, and we'll keep refreshing there. All right. Okay. So we'll watch the phone and see if our local will call in. Who was it that was going to call? Let me remember. Is it Elizabeth? We'll see. Buck Hermit, welcome. Glad you could wake you up a little bit here. Lunch hour. That was a little loud. Sorry about that. It was a little loud. I'll turn that down a tiny bit. Turn that off. Turn that down, and make that on demand. All right. Let's see. We have this court is a hot mess. Wow. I feel bad for the defendant. The lawyers, the judge don't seem to know the law. I think I know why the judge was so distracted and making wrong rulings. We'll see who this is.
Call from Elizabeth Spencer.
Hello, Elizabeth. This is R.A. How are you doing today?
Hi, R.A. This is Elizabeth, and my husband, Butch Jones, is with me.
Hey, wonderful to have both of you. Now, you have to tell us first, where are you calling from?
We actually live in Spanaway, Washington, which is about, how far are we away from?
About an hour from Tumwater.
About an hour from Tumwater.
Right next to Thurston.
So this is home sweet home.
We're
home sweet home for you guys.
Yes. I've actually been following both cases.
Mm-hmm. Mr. Farrak and this
is
Mr. Farley.
Insane.
Now, tell me, this is only our second case in Tumwater in Thurston County. What's in the water up there? Is this normal? Do you guys have like an added measure of crazy up there?
My husband could probably fill you in more of the craziness that goes up there in Olympia area, but it's pretty much every day. I don't think he knows about this case. This is the one when the
First Amendment auditor. Yeah.
The First Amendment auditor at the DSHS.
Oh my God.
Suddenly Butch remembers. Like, you're watching that one?
No, but those people are they're not as bad as Second Amendment auditors.
No.
They're a unique breed of people. And honestly, I will tell you, from like in my heart of hearts, as a lover of the law and the Constitution even, I think that he has a legal right to do some of what he does, and I hate what he does with that right. It's like the right to free speech, but the person who is using the free speech is swearing and cursing and questioning my parentage. It's that sort of thing. I'll defend your right to free speech, but I hate what you're saying in doing this. So I'm not giving this guy like carte blanche, approval of everything he does. But wow, the trial itself, the case itself, it seems like this is not normal. I mean, we've got a lawyer who says, "Oops, I messed up and excused the wrong juror," before we even begin. In Mr. Farrak's case, you've got he leaves, just abandons court midway through, right when it's time for him to present evidence, and we've got a warrant out for his arrest. Where else do you see that? Somebody just bail on court halfway through.
You would see that in Olympia.
Just Olympia.
Olympia is LA. Law-wise.
It's a very interesting setting. As far as the judge goes, tell me a little bit about this courtroom.
Well, as you can see, it's not an actual courtroom. So you like, I can literally, I haven't even told my husband this because he just woke up, ironically. When you see the courtroom, it literally is like the DSHS office. So you have all the chairs just sitting there. You have the tables right there. And then you go and look when they did the witness stand. It's just one little desk.
It's a little student's
And
desk.
I'm like, oh my God, this is deja vu. This is DSHS. Are we literally having this court hearing in a DSHS office?
It's interesting. There are some other courtrooms. I mean, you do have, proper courtrooms, but
We do. I honestly don't know why. I don't know why they did this room for this court hearing. I don't know why, and they have it that way for our other trial too. And I was like, this isn't our courtroom. Like, literally, this is the capital of Washington, and this is what they give us.
I wonder if they're doing this because they're really frustrated with the defendants and the fact that they're taking this to a jury trial, and so they give them this. Yes, technically it's court, but it's not really a courtroom. You're not taking us to court, and the judges seem to be. I would just say they seem to be less experienced in this room. Are these our normal judges up there?
Our judges don't want to send criminals to jail unless they're they're criminals because they're trying to.
They don't really want to have to be doing this. This is not something they would rather be doing. As soon as they can get it over with, the better. They're like, why are we even here? Type deal.
Bob Ferguson is a nut job.
Yeah.
I'll just steer clear of that one. Tell me, what was your impression of the witness, the second witness, the gentleman who was there at the DHS office? He was so excited to be there.
I have seen him when we went to DSHS before.
All right.
My husband probably doesn't even know it, but my daughter. Okay, Aria, mommy's on the phone.
Hey, Aria.
I have a child home sick, but
It's almost Aria.
yeah. No, but I know who he is, and if it's a security guard, I think it is, then I know who he is too. So, it's just all. It's the part where like everybody knows everybody.
Yeah. It's a little crazy. Any desire on your part to wander down to court and observe yourself? Is that...
No, not that early in the morning. It's too cold.
Right.
And I need a driver's license.
Yep. You need that. Wow.
No, but yeah, this has been crazy. And I've been watching your channel for months, and it's so weird that I have to wake up at like 6 o'clock or 5 o'clock to get you live. Now now you're in my time. So
just for a couple days, we're on the West Coast time. So that's awesome. Elizabeth, thank you so much. I appreciate you giving us a little insight, both on the phone and through chat, to your hometown. Hey, Aria, how are you doing?
Some ice cream?
Yes,
no, you
yes.
cannot have some ice cream. Can you say hi to Mr. R.A.? Look, that's him on the TV. Say hi, R.A.
Hey, Aria, if you can hear me, I'm going to give you permission to have ice cream. Is that okay? I'm just kidding. I'm sorry.
You're now her favorite person. Thank you.
Thank you. Elizabeth, Butch, Aria, thank you so much for calling in and speaking to us. We appreciate it.
All right. We love you guys.
Yep.
Bye.
Have a great day. We'll see you.
Bye.
Bye. Oh, that's funny. That's funny. Wonderful. All right. We're going to take a little bit of a break. This case isn't over. I think, first of all, this defendant is going to come back after lunch. I think he's coming back after lunch. He's not going to pull a Mr. Farag. And we'll have part 2. It will be starting in, it'll be starting in about 45 minutes. So we're going to be gone for about half an hour. Actually, my inspector is here again. Hopefully this is the final inspection, and then Airbnb's good to go. I mean, we have the pillowcases and the bedspreads and the curtains and everything is up. We have shampoo and conditioner and the towels. The entire thing is stocked, and we're still waiting for the inspection. So hopefully the inspection goes properly. We don't have to pay another $75 for him to come out again later. But anyway, so I'm going to go audit the inspector really quickly and film the whole process and see what he thinks about that. And no, I'm not going to do that. I'll just keep my fingers crossed, my mouth shut. Anyway, that's it. We're going to take a break and come back for more. So buckle up, because I think we have one more witness. I don't think we have any defense witnesses, and I don't think this defendant is going to speak on his own behalf. I don't think he's going to testify because he knows his right and he exercises his rights. And one of the rights is that he doesn't have to testify in his own defense. And I think he's going to exercise that. We're going to break for lunch right now. Thank you. No mandates, not a fed. Appreciate that. So with that said, we will start the music. We're going to go to lunch. TC, thank you so much to all those who joined today. We had a bunch of new viewers join. Welcome. I hope you enjoy it here. Sometimes the cases we follow are much more serious than this one, and even dealing with a lot heavier facts. This one's a little bit more lighthearted. Still serious issue. Still a constitutional rights. This is something that's worth defending and worth fighting for. Apparently, the fight, we haven't heard any testimony of. Supposedly there was an altercation. Somebody got punched. And there's a video of it, apparently, but we have not seen the video. So we're waiting to see the video, and we'll see what happens from there. But right now, if the judge were just calling balls and strikes on both sides as he sees them, I think a directed verdict would be in order. If the prosecution were to arrest right now, I don't think they proved their case for assault. I don't think so. Anyway, have a good lunch. We'll be back in about half an hour, and then we'll keep going at 4:15 Eastern time. Hit the like button on your way out, says Ashley. Thank you so much. Those hit the like button. That makes wonderful things happen for the channel. Just everything turns up roses when you hit the like button. So thank you so much. All right, have a good lunchtime. We will see you. Oh, hey, welcome, Kurt, an uncivil law Lollapaloolians. What is an uncivil law member? Uncivil lawyers? No, because that's like... No, Kurt, welcome. We're just barely jumping out for lunch. We have a crazy trial going on right now. Just an absolutely crazy trial. It's nuts. It's only a one-day trial. We're up in Washington. It's great. We'll see you guys after lunch for part 2. You don't want to miss it. We'll see you in a bit. Bye.